Buenas and half a day. The Committee on General Government Operations, Appropriations, and Housing is now called to order. Today is Thursday, June 30th, 2022, and the time now is 2:03 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Wednesday, June 22nd, 2022, and again on Tuesday, June 28th, 2022. Again, today is Thursday, June 30th, 2022. The following items will be heard in this afternoon's public hearing. Bill number 302-36 COR, introduced by Joanne Brown and Telo Taitague, an act to amend section 1908B2 and 19091 to add a new section 1925, all of chapter 19, Title 1, Guam Code Annotated, and to add a new section 6325D6 to Chapter 6, Title 4, Guam Code Annotated, relative to enhancing the independent status of the Office of Public Accountability by opening a depository account with Department of Administration by continuously appropriating 0.25%, 0.25% of the Government of Guam's annual budget to the OPA, creating eligibility for a pay increase for professional staff, and authorizing the establishment of a salary. And Bill number 310-36 LS, introduced by Joe S. Agustin, Telena Cruz Nelson, Amanda L. Shelton, and Tina Rose Muña Barnes, an act to amend subsection D to section 58D103, amend subsection B of section 58D104, amend section 58D108, and amend section 58D109, all of chapter 58D, Division 5, Title 5, Guam, all to facilitate the financing of an education facility. I'd like to thank my colleagues who have joined us, Speaker Therese Terlahi, Senators Brown, Taitague, and Moylan, Sidious Masi colleagues. Those testifying on behalf of Bill 302-36 are invited up. I think we have a full panel here today, and these are just some reminders, some general rules for the public hearing. Written testimony shall be submitted to the committee. Please provide the legislative staff with your written testimony for photocopying. Testimony may be read, and lengthy testimony should be summarized to about 5 minutes. Those testifying will be allowed to present oral testimony. Once you are done, please remain in the room for questions or for additional testimony, as may be desired by members of the committee. Questions and testimony shall be confined to the substance or nature of the agenda, and personal inference as to the character or the motive of any senator or any individual testifying is not permitted. Any violations of this general rule of conduct will result in removal from the public hearing. Proper form and decorum shall be practiced by all present in the public hearing room for this proceeding. Individuals who fail to maintain proper form and decorum may be restricted from providing oral testimony and may be asked to leave or be escorted or removed from the room. When you speak, please make sure that your microphone is turned on and that you speak into the microphone. When you are acknowledged, please state your name for the record. I'd also like to thank Senator Nelson for being here. We will begin now with Bill number 302-36. I invite the main sponsor of the bill to give an opening statement.
Thank you very much, Madam Chair, and certainly good afternoon to everyone that's here to testify with regards to Bill 302. Madam Chair, and to the public and my colleagues, my primary focus in the introduction of this bill was to ensure that the Public Auditor's Office be able to operate as intended. And a number of years ago, we used to have an appointed public auditor. And as policymakers, we felt that in order to ensure the independence of the Public Auditor Office, the public auditor should be an elected position and an elected office, as we also did with the Office of the Attorney General during my previous tenure in the Guam legislature. While the Office of Public Auditor continues to fulfill its duties and obligations to our people in annually reviewing and doing audits in each of our Government of Guam agencies, we've certainly found since that time that when the public auditor determines that there's additional concern as a result of their audit, there's very little option that's available to the Public Auditor's Office to actually pursue any action that they may determine to be improper, unethical, or outright corruption in this government. I certainly want, through the process of this bill, to allow the public auditor to enter into a formal agreement with the Office of the Attorney General, and also that we look at funding those positions to include an investigator and staff assistant as needed to facilitate if the public auditor determines that an action in terms of the review of their audit requires additional investigation. If such, that option should be available to the public auditor. Another critical issue the public auditor has repeatedly brought before this legislature, and as I know it's happened with the previous public auditor, I thank Doris Brooks for being here also to provide her testimony, but is the challenge of being able to maintain qualified public auditors and sustain them in the office. Because granted, you know, there are other opportunities available for their skill set in the government, in the federal government, and in the private sector. And we want to ensure the public auditor has the competitive advantage and ability to keep qualified, experienced staff on board. More the reason to ensure that they're following through and doing the audits that are needed on behalf of our people, and more importantly, on behalf of the funding that they provide this government. Our government has grown to close to and over $1 billion in operations. The amount of money that we're asking to connect the budget of the public auditor to the overall budget of the government of Guam is minuscule in comparison to the tasks that they have before them and the work they have before them. Their job is to ensure accountability and ensure that the people's dollar, the public money, is being properly spent. And I think they need the tools to be able to do that. So overall, certainly we can go and review and discuss the other components of this particular bill, Bill 302. But those are the main critical components that I feel is very important to further strengthen the Office of the Public Auditor and also ensure the autonomy and the ability of the public auditor to also be able to sustain currently his staff, his experienced staff, to be able to do the work that we need them to do independently and without interference from the rest of the government. With that, Madam Chair, thank you for the opportunity to be able to provide my opening remarks on Bill 302.
Situus Masi, Senator Brown. And now I'd like to invite the panel who have signed up to testimony. Will begin with Mr. Sedfrey Linsangan. Please state your name for the record, sir.
My name is Sedfrey Marcelo Linsangan. Good afternoon to all of you senators. Yeah, I oppose this bill because it's contrary to the legislative findings and intent. Based from my experience with the OPA, I filed 4 cases against UOG 2 times and against against DOE 2 times also. OPA did not carry its mandate. It did not execute its duties and responsibility. And that's what this bill is all about. You are trying to give them increase so that they can execute their duties and responsibility. You know, what happened is they had engaged in extraordinary conduct or action. I filed my case against UOG. The UOG lawyer introduced a motion to dismiss for lack of jurisdiction. And then the public auditor, Cruz, he made a ruling to dismiss my case without prejudice because he found the deficiencies on both parties. He said that I filed too early. I told him, yes, I filed too early because they're not responding. They're not following the rules. They don't even provide the bid status for 3 months and the abstract of the bids. Even I've been following up almost every week. And then they don't reply to the agency report. You know? That's why it was a good decision by Public Auditor Cruz to dismiss the case without prejudice because I can bring it again so that they'll be given the opportunity to provide the agency report and the response. The agency response to my protest. However, when he made that decision, I made a motion for reconsideration. Then after a week, he recused himself. Yes, he recused himself. He said, because he has association with me as a former Democratic Party. Then he imagine that after hearing my case, then afterwards, he recused himself. And then he appointed his former legal researcher, attorney, he's here, Attorney Joseph McDonald. He's my friend too. And what I don't want is, he said, oh, I made my own rules. You have to follow my own rules. He's only a hearing officer, and the hearing officer's duties and responsibility are all stipulated in the procurement law. And he dismissed my case one day before the final hearing. The subpoena that he signed, I served it to UOG president and to the procurement officer. One day before the final hearing, he dismissed my case for lack of jurisdiction. He said, because I'm not a lawyer. Of course, that's what the UOG counsel stated on the day, 2 days before the final hearing. He included that, that I should not be representing myself. And then the OPA has all the jurisdiction to allow me to represent my company in the procurement appeal because I'm an officer of the company. It's been, again, in the OPA procurement appeal, I also may hire a lawyer if I want to. But I decided to represent my case. In fact, since OPA has been established for 30 years, they've been accepting officers of the company, to represent their company. In fact, Public Auditor Brooks heard my appeal 2 times. And what made Attorney McDonald smarter than her, than the late Senator Sonny Shelton, then Attorney Cruz, that our former Office of Accountability also head, and other OPA people that became the head of the OPA. That's why, if they cannot do their duties and responsibility, then it's connected to professional and administrative corruption. Because even if you stop Auditor Jeric Hernandez, he's the one responding to my motion for reconsideration. He don't have any authority to respond. That's not his duty. He's only an auditor. And then 4 motion for reconsideration for the 4 cases, he did not posted it to the website. But one he posted, then the next day he took it out. That's a misconduct on his part. And who gave him that authority to sign for the ruling? The only memo we got from Public Auditor Cruz is, if you have any question, contact Mr. Jeric Hernandez. And the other part is, the UOG Council tampered the procurement records. He redacted the email correspondences between him and the procurement officer, Emily Gumataw. 2 documents. That's a criminal conduct too. And he get away with it. Instead, they dismissed my case. But when JMI sent a letter to Public Works calling him a bro, he dismissed the case right away because the integrity of the case is at stake. So what's happening with OPA? They're supposed to hold those agencies accountable. Now they hold me accountable by dismissing my case because I'm winning the case based on merits. They cannot stomach the case that I can win the case, even though I'm not a lawyer. And they want to cover up the wrongdoing of the UOG president because he's signing the agency report even though he don't know what's happening. He's covering the tampering of documents of Attorney Camacho. He's covering the wrongdoing of the Emily Gumataw who doesn't even know the procurement rules. That's why I'm not only frustrated, but I'm also angry. But I have to go to this process. And that's why now you will give them reward, especially that I read in your website that you're running for re-election because to end corruption. Isn't that corruption?
Mr. Linsanga, thank you very much.
No,
You're over
I have
the
some
5
more.
minutes. If I can just ask
Okay.
you to wrap it up, please?
Okay.
Okay. Thank you. If you'd like to submit
You
more,
want me to wrap it up for how many minutes?
oh,
That's it.
you're over the 5 minutes,
Oh,
but
okay,
I'll
okay,
allow
okay,
you
okay.
to wrap it up if you'd
Yeah.
like. Okay, thank you very much.
Oh,
We'll move
okay,
on
yeah.
now.
That's why if you will establish a payment scale to be to all line agency, not only to OPA, and you also have to establish a pay scale for all elected officials. Where can you find a senator getting lower salary than the vice mayor, than the mayor? Come on. You need to upgrade yourself. That's why it needs to be included on establishment a pay scale for not only for all auditors or accounting degree, but also for all elected officials. It doesn't matter if the economy is down or not. You need to put some integrity in this body. And also, do not support this bill because the integrity is at stake. What he should do is he need to resign to bring back the integrity on the APA because right now the OPA is in a mess. And they betrayed the people's trust.
Thank you very much, Mr. Linsanga. Now we'll move on to the Office of the Public Auditor, Speaker Benjamin Cruz, and we have with him Vincent Duenas and Legal Counsel Joseph McDonald.
Thank you very much, Madam Chair. I'll read my testimony on the bill. The Office of Public Accountability submits this testimony in support of Bill 302-36, introduced by Senator Joanne Brown and co-sponsored by Senator Telo Taitague. And we have some suggested changes to the format and the language of the bill, and they're attached. Bill 302-36 seeks to address the statutory obligation of the OPA to be independent of the executive, legislative, and judicial branches. Our independence assures accountability and efficient, effective management throughout the government of Guam, and the principle of independence is paramount according to the generally accepted government accounting standards, GAGAS, and the International Standard of Supreme Audit Institutions, ESI. Our independence should not be compromised, and it is supported and should be supported by continuous training to maintain a professional and competent staff to carry out its mandates. Independence is realized and exercised in different ways. In this bill, Section 2 proposes to address the independence in several ways. In Section 2, the bill proposes to address independence as it relates to the way that we address the preparation and payment of financial audits. Currently, the practice is the OPA oversees the procurement and the selection of the external auditor who conducts the audit. The current practice also has the audited agency paying the external auditors' bills submitted by the audit firms, fostering an impaired relationship between the agency and the external auditor. This practice creates a potential risk that an agency could potentially persuade the external auditor to issue an undeserved favorable audit opinion for the agency because of the fact that they're making the payments. I am concerned about the possibility of an Enron situation scenario occurring here on Guam. To prevent this from occurring, Section 2 proposes to have the OPA handle the procurement and the payment of invoices using funds by the agency that the agencies have deposited into a special trust account created for the specific purpose of paying audit invoices. The agency should deposit the amount as stated equal to the contract cost. The external auditor would submit the invoices to the OPA, and the OPA would determine if the product meets the contract terms and if the invoice should be paid. This arrangement makes the OPA the oversight contractor and payer, and the agencies the subject of the audit. This policy is similar to our neighbors, the Commonwealth of the Northern Marianas, where the public corporations and the autonomous agencies are required to pay, quote, not less than the greater of 1% of each agency's total operation budget from sources after the legislative appropriation or pursuant to any other formula upon which the public auditor and the agency may agree, end of quote. And that's from section 7831B of Title I of the CNMI Code. Independents can also be impacted by the budget provided to the OPA. Many of you can recall when the Mueller report was being discussed by Congress that an acting Attorney General suggested that the way to mute Mr. Mueller was to, quote, to starve his operation by not providing it a budget. I believe that the OPA should be able to issue budget audits without fear that any of the findings and recommendations could be retaliated upon by the legislature, refusing to provide the OPA with a reasonable budget, or the executive withholding budgeted funds. Section 3 proposes to mandate that the OPA receive a budget equal to 0.25% of the general fund. Again, this draws on the example of the CNMI, where their OPA receives a guaranteed annual budget that is not subject to the transfer authority or appropriation by the legislature. The bill also mandates that the Director of Administration, that the Department of Administration timely release 1/12 of the appropriated funds every month. This language in Section 2 of the bill proposes that each year at least 0.25 of the annual general fund revenues be appropriated to the OPA. I will leave it to this body to decide whether it is the appropriation level should be 0.25 of the annual gross general fund revenue, similar to the calculation for the annual provision for tax refunds, or 0.25 of the total general fund revenue available for appropriation. I've attached a chart that shows the difference, what that 0.25 would mean over the last several years and what it would mean this year. In the event appropriations are decreased and the 0.25 set aside revenues is not enough to sustain the OPA's operation, we recommend amending the bill that adds a provision for a guaranteed annual budget of $1.75 million as a safety measure to assure that the continuity of the operations of the office. This is similar to the CNMI OPA budget, where, quote, the Secretary of Finance is required to withhold 1% of all amounts appropriated by the Commonwealth law for all government agencies, operations, and activities, as well as for all capital improvement projects, except the legislature, and in no event shall it be less than $1 million. And that's from the CNMI Code, Section 7831A. If passed into law, our office could be able to absorb the cost of long-awaited implementation of the leading edge compensation study completed in 2014. As I have testified during our budget hearing in July, at least 10 of our employees have left the OPA to pursue higher paying positions elsewhere. Many of them received double-digit increases in salary at their new positions, for which minimum qualifications of a master's degree is not required, unlike the requirements for Accountability Auditor 3 positions within the OPA. Several of these previously had supervisory and management level positions in our office. Of the 14 staff that I currently have today, only 3 of them have more than 10 years of auditing experience. One of them has about 5, and the remainder have less than 2 years experience. This loss of the auditor 2s and 3s within the past years has severely impacted my office operation. My auditors 3s and 2s are stretched thin, overseeing teams of new auditors who are writing their first audit and are the only ones qualified to do the quality assurance review of completed audits, while also performing a myriad of other managerial and administrative duties. Though we have successfully issued all the financial audits, save for the GUAM audit today, many of our performance audits are severely delayed. I would like to thank the authors of this bill for the authority granted in Section 4. I know that many of you wanted to authorize the OPA to establish a legal division to prosecute enforcement of our findings and recommendations. The authors understood my apprehension at creating a whole new division within the OPA. I thank them for recognizing that we should move incrementally and for understanding that the independence of the office has to first be recognized and firmly established, and also thank them for recognizing that we have to first bolster and build up our core mandate of the public Office of Public Accountability, and that's our auditing. By providing funds and foundation to hire a cadre of properly compensated accountability auditors, the office will continue to produce performance audits and promote accountability and efficient operation of all government agencies. And I believe that the authorization granted in Section 4 is perfectly measured toward that step. Section 5 seeks to further strengthen the office's ability to attract and retain qualified professional staff by establishing a salary scale that would be helpful to bring some parity within the autonomous and semi-autonomous agencies that continue to offer higher salaries than the positions and are not unique to the agencies, but common throughout the government of Guam and at a lower scale. An updated salary policy based on the highest salary paid by the autonomous agencies would attract, preserve, and sustain professional staff. The bill directs the public auditor to meet with the Director of Administration and together design a salary scale that would provide parity. Though I appreciate the power, I would be hypocritical for me to promulgate a salary scale that was not scientifically and empirically based. Such a salary study would take some time to complete. Time is of the essence, and I cannot afford to lose any accountability auditors 3 or my lone accountability auditor 2 to another autonomous agency. I hope that while the Director of Administration and I conduct this empirical study, that this legislature mandates the immediate implementation of the leading edge study as it was originally issued in 2014. I realize that it might be 8 years old, but if I could just offer my senior auditors a small increase and I could assure them that I am working on a study that would provide them the increased salary that they deserve. We agree with the proposed timeline in Section 6, and I thank you for your attention. Thank you, and I'm here for questions. I've attached proposed wording, and also, for those that weren't at my budget hearing, a comparison of the salary scale of the 1s, 2s, and 3s in the office currently, and what that current comparison would be if we have the leading edge one, at least as a interim. Thank you.
Thank you very much. We'll move on now to former Public Auditor Doris Flores Brooks.
Okay, I'll start again. Have a day, fellow senators. Good to see you all. It's been a long time since I've been in this august chamber. It's nice to be back. Okay, I have written testimony and I would like to read it. Okay. As the retired public auditor of Guam, and in my current position as Director North of the Pacific Association of Supreme Audit Institutions, better known as PASI, I am here in full support of Bill 30236, sponsored by Senators Joanne Brown and Telo Taitague. I commend the sponsors for their foresight in giving the Office of Public Accountability greater independence and autonomy. Independence is the foundation and hallmark of an effective Supreme Audit Institution, or better known as SI. A strong, independent SI is essential for a country's good governance and public financial management. The expanded philosophy of the importance of independent audit institutions is that SIs are partners, and I want to stress the word partners, in oversight responsibilities with their legislatures. The legislature wants more accountability and transparency of government funds they appropriate to government agencies. SIs provide this oversight, accountability, and transparency through the many audits they issue and contract out. Bill 30236 provides for a minimum annual budget appropriation of 0.25% of general fund revenues. And as Senator Brown said in her opening remarks, this is minuscule compared to the billion-dollar, and I stress the word billion-dollar government of Guam that we have. And that's just the main executive branch, excluding the autonomous agencies. So when you look at that altogether, the government of Guam is in excess of $2 billion in revenues overall. You know, we are not chump change. We are a big government. Shortly after my election in November 2000, legislation was passed to delete this funding provision. As the newly elected public auditor, I did not challenge this detrimental change, as there were so many other issues to pursue as the head of a newly created agency. This set-aside funding provision is not uncommon. Our neighbor to the north, the Commonwealth of the Northern Mariana Islands, Office of the Public Auditor, receives a set-aside not only of general fund revenues, but also of autonomous agency revenues. It should be noted that the CNMI autonomous agencies have not been contributing to OPA's appropriation. Accordingly, their general fund has been subsidizing the shortfall. Presently, CNMI OPA has a budget in excess of $2 million. So what will this provision cost the general fund? Based on the audited FY 2020 general fund revenues of $782.3 million, OPA would have received an appropriation of $1.96 million compared to their current FY 22 budget of $1.65 million, an increase of just 310%, or 19% over their current budget. This is not a significant increase, and is actually minuscule, but reflects more the importance and independence of OPA. Another section of the bill provides for autonomous salary comparability, a provision that is desperately needed. OPA has and continues to be the trainer/recruiter of choice. When OPA employees left for other government agencies, I used to try to look on the bright side, that seeds of accountability and transparency were being planted at these agencies. However, that left OPA with an empty garden, requiring much more time and effort to gather new seeds, plant again, nurture, and harvest. That is, to recruit, develop, train, and retain new employees. On average, it takes nearly 2 years for a new OPA employee straight out of the College of Guam, the University of Guam, with little to no working experience to become reasonably productive in auditing. I have lost track of the number of OPA staff who have transferred to the autonomous agencies during my tenure and continues nonstop today during Public Auditor Cruz's time. And he just mentioned he's already lost 10 people in the last 2 years. OPA presently has a staff complement of 14. Excluding the administrative officer, the average tenure for auditors, including the public auditor, is just 4.25 years. The two most senior auditors have been at OPA for 15 years and 13 years, respectively. For an organization that is nearly 30 years old, this is a very low working tenure. Much of OPA's institutional memory has been lost with the departure of so many senior staff. While OPA is in the midst of developing new institutional memories with the next generation of auditors, it will not be without hiccups and challenges. Just this fiscal year, OPA lost 2 senior employees. One left in October for the federal government, going from a salary of $62,371 to a salary of $72,000, an increase of over 15%. Another OPA employee left in March, just a few months ago, to an autonomous agency, going from $49,093 to $62,109, an increase of 27%. For OPA to retain staff they have invested heavily in training, OPA should be given the ability to offer competitive salaries and to be able to retain their employees. Many an OPA employee has said that they like and enjoy working at OPA, but with families to support, they cannot say no to such significant increases in salary. Another provision in the bill calls for OPA to pay the cost of financial audits of autonomous agencies from autonomous agencies funding, are consistent in furthering OPA's independence and ensuring that the contracted auditors work in harmony with OPA. In closing, I again give my full support of Bill 30256 and urge its passage. Thank you, and si Juice Maasi, and I will stand by to answer any questions you may have.
Situus Maasi. We'll now move on to Douglas Moylan.
Half a day, Madam Chairperson Shelton. Half a day, Madam Speaker, sponsoring Senators Brown, Senator Taitague, as well as other distinguished senators here. I am among distinguished individuals to my right and to my left, including the public officials that served as the elected public auditors. I am in support of this bill 302-36. Having served not only you in several legislatures of the past as the legislative counsel, and have been honored to have served as the first elected Attorney General, I believe that the two speakers before me that were elected by the people are essentially indicating that they are the government's watchdogs, that they are the people that have saved our government money and prevented the taxpayers from not losing that to whether it's mismanagement, corruption, or what have you. Section 4, I wanted to take the time here to offer the senators to maybe consider first of all, the powers and duties of each of the offices that are being affected by this statute, the bill that's being proposed for a statute. The first being the public auditor. I believe that Public Auditor Cruz eloquently stated that he needs the funding in order to do a good job. Without the funding, they can't do their job. Having been in the AG's office and worked with former public auditor Brooks, the AG's office and the public auditor worked hand in hand as one of the functions of the Attorney General's office in order to protect the taxpayers, protect the voters, protect our community against mismanagement. And I'm not talking just about the criminal aspects of it, but also the mismanagement that mistakes are made, and it's the public auditors that do the job of accounting for the money. There's a statement among criminal prosecutors that you always have to follow the money. Well, in any government, when there's so much money, as the committee has indicated, $1 billion is currently the budget. I think when I was back in the 24th Guam legislature serving you, it was 400 million. So it has grown tremendously. But the public auditor's office hasn't grown with the size of the government. And they indicate the problems with the autonomous agencies, which are money-generating agencies, outbidding this limited supply of auditors. From the Attorney General's office perspective, when I served, and I do not want to disrespect the current Attorney General, but when I was in that office, it was always a function of how much resources each department or entity, elected official, could bring into that agency in order to do a good job and do the services required of them. In terms of Section 4, may I propose that maybe in addition to or in replacement of having an Assistant Attorney General sent over to the public auditor, that the legislature consider creating, like it did with the Consumer Protection Division at the Attorney General's office, and making statutory a division within the Attorney General, government corruption, public integrity, public accountability, however you wish to term it. And I can guarantee you that the Attorney General will be working hand in hand with the Office of the Public Auditor in order to fulfill the functions and duties that the senators may identify for that division of the Attorney General's office. Currently, the Attorney General has the ability to set up different divisions, whichever Attorney General goes in there. When I went into the Attorney General's office, we created the Government Corruption Division, which worked with the accountants of the Office of the Public Auditor, but most especially with the Public Auditor herself. The only other division that has been mandated in Guam law by the senators was the Consumer Protection Division, which again it's an important division to have in our government, but I would respectfully submit that a more important division to have within the government, and mandated that the Attorney General have it within his prosecutorial and civil duties, be an office or a division of government corruption, dealing with government corruption. And again, in our experience, in the 4 years that we were there from 2003 to 2006, Doris Brooks and her accountants were constantly coordinating with the AG's office to investigate, to review, to bring in individuals regarding those audit reports and findings. And several resulted in actual civil relief, criminal prosecutions, but that is the nature of the beast for which you are addressing here. These individuals are law enforcement officials to the extent that they need their autonomy, they need their independence, and they need the funding in order to do a good job. Without the public auditor's office, the Attorney General is less effective. As the senators know, in the federal model, the FBI is essentially made up of lawyers and accountants. I think way back in the early history of the Federal Bureau of Investigation, it was set up not necessarily to fight the violent crimes in the federal government, but to fight the white-collar crimes. And that is one of the arms and powers and I would respectfully submit responsibilities of the public auditor is to provide that white-collar analysis of the money. You know, some might also argue that the greatest injury to our taxpayers, equivalent to the person that commits the violent crime, is the person that takes the taxpayer dollars, and especially if it's not detected. The AG's office is not equipped to be a public auditor. They're equipped to look at the law, look at the facts as they're presented, and then figure out what to do, and that's in the office of the elected Attorney General himself. But I would believe that to make for a full law enforcement as it comes to the white-collar crime area, you need the public auditor to be properly funded, and you need the Attorney General to have that division set up within the AG's office. And I would also not caution, but please be aware that the statutory scheme that the senators have established creates the public prosecutor is the Attorney General, as you guys are aware, and also has a civil arm. There's 3 states in the United States that actually have the Guam model, and that was Alaska, Rhode Island, and I believe Delaware, where the Attorney General serves both the civil side and the criminal side because of the size. If the larger states, because of the mere size of them, they have what they call district attorneys, so they separate the 2 functions. So if the legislature was to have an Attorney General's office with the current powers and duties it has now, the public auditor would be essentially the investigator, as it is serving right now, for the Attorney General on that limited basis. I'm not saying that's their full scope of their responsibilities, but if you have a problem with the public auditor's office or the Attorney General, I would hope that the senators don't start pulling apart the powers or intermixing them. I'm always worried when they put an attorney mandated at a department or agency, because you get into questions on who controls the attorney at that agency. Back in when I was there in 2003 to 2006, the Supreme Court made it very clear that the Attorney General must follow the legislative mandates on what's the power and scope of its duties. In this bill, it's seeking to send over an attorney, and I respect the fact that it's by memorandum. So you would need the public auditor and the Attorney General to both agree, yes, we'll send over an Attorney General, and I see how that person sent over there would be an Assistant Attorney General. At the same time, if the legislature was to decide, we don't want this just to be the OPA, but to have a division within the AG's office, you would basically, that division would be a function of the public auditor. That whenever an audit report came out, the public auditor would come over and send his people over to the division of the Attorney General's office, as we have done in the past before. And again, I use Senator Brooks as that example. There's also bureaucracy, there's efficiencies that would be achieved if you made it within the Attorney General's office. This division, responsibility, and attorneys that would be under the Attorney General, but also be working directly with the public auditor. And you also wouldn't get any conflict issues going on where the public auditor would potentially get into a prosecutorial mode. When we were there, Doris's accountants, Senator Brooks's accountants, were the witnesses for purposes of presenting the cases to the juries, whether it be a civil or a criminal matter. And senators, at that, one final note, and this goes to that powers and duties and ensuring that there may not be an overlap between 2 functions of our government, that the Attorney General's office has traditionally been seen as the entity that protects the public interest. Of course, we all protect the public interest to a certain extent, the Attorney General provides the uniform legal policy throughout the government, which would be, if the senators decided to put the AG's office or create something where they work directly with the public auditor, you would create that uniform public policy, because the public auditor would provide the information to the Attorney General's office, i.e. the elected Attorney General. And then the last function was you would save money. The function of an elected Attorney General is to save the government money, so you're not paying attorneys on an hourly salary as opposed to a salaried employee. So having said that, I will submit and thank the committee for its time, and make a comment that I see a problem that I never knew about, that the public auditors are losing attorneys to the, the public auditor is losing attorneys to the autonomous agencies. Well, I think it's within your scope to set the salaries so that their higher salary won't be competing against an OPA salary, whether that be to increase or decrease or just equalize. And again, that one of the benefits of the Attorney General is that they set a uniform pay scale for attorneys themselves. Thank you.
Thank you very much. Okay, I'd like to call up Mr. Byrne to give testimony. Please state your name for the record.
Senators, good afternoon. Edward Byrne, Director of Administration. I really was undecided as to whether to address this bill this afternoon, but some issues have come up that, with your indulgence, I would like to address. It is perfectly close, thank you. With regard to salaries, I think you have heard me express in budget hearings that Department of Administration suffers from the same draw of the autonomous agencies which the public auditor referred to. I'm an accountant, and I obviously support not only continuing professional education, but as much education as is possible for accountants to be able to do their job. And accountants at the Department of Administration are responsible for the preparation of the numbers which are audited. It would therefore be incumbent on me to point out that we need those salary increments to be available to those accountants in the Department of Administration who are doing an equally important and vital job. I too have lost several accountants to autonomous agencies, some of them doing, as the public auditor mentioned, work that was not as varied and extensive and, dare I say it, important as the work that they were doing at DOA. I obviously would be more than happy to cooperate with the public auditor in assembling, devising, and putting together a salary scale to address the concerns that he's expressed, but I would like, obviously, to be able to address the concerns that I've expressed. The actual mechanism that's proposed here for paying audit bills, I don't really have too much of an issue with, except in the circumstance where there's an unpaid bill. You know, auditors are reluctant to issue audits when there's an unpaid bill. So I think it would be helpful to hear a little more information on how that would be addressed in that circumstance. There's also the circumstance where accountants perform services that are not actually audit, but are related to audit. And in particular, when agencies where the central government or autonomous are issuing bonds, there's a requirement to have a preliminary operating statement and an operating statement, both of which are reported upon by the auditors. This isn't an actual audit, but it's a related audit service. That's not addressed in this bill, and how that would be compensated, which is usually through the bond cost. That's not addressed in this bill, but probably would have to be if there were no other source of income to pay those particular bills for those services. I certainly support the need for independence of the public auditor. It's very hard to maintain that independence, and the accounting profession has set up a lot of rules and regulations in all jurisdictions to make sure that that independence is maintained. Lastly, as some of you probably recall, DOA has set up an internal audit division. The purpose of the internal audit was to be able to provide what I would call fast audit conclusions on issues that DOA sees come up. And DOA sees these issues come up from time to time. I think I mentioned the other day in this hall that these reports are actually on the DOA website, the ones that we've issued so far. But they also perform a vital service, and they also, hopefully, would be included in this salary study in order that they don't get drawn away, and the internal audit department at DOA can continue to do its job. Thank you for allowing me to address these points, which certainly occurred to me as I was listening to these distinguished ladies and gentlemen talking.
Thank you very much, Mr. Byrne. I'd also like to acknowledge Senator Ada, who is here with us in this hearing. We will begin with questions for the panel. Speaker. Mr. McDonald, will you provide testimony, or are you here to answer questions?
I invited Mr. McDonald to join me today. He is one of my legal counsel and hearing officer for the office. But there is a problem that we're currently experiencing in the Superior Court that I thought that he might enlighten the committee on, and hopefully it might be addressed, since it's going to, the bill is all about the Office of Public Accountability. I thought maybe if he could address that one issue. If you could.
Thank you, Public Auditor, and thank you, Madam Chair, and good afternoon, honorable senators. I'm Joseph McDonald. I'm a practitioner in private practice, but I also serve as legal counsel to the OPA. And you guys probably know, prior to my getting into private practice, I was at the Attorney General's office and helped to spearhead their white-collar group. And I can tell you that the OPA is basically the other side of the white collar, exactly like General Moylan was saying. Just as a backdrop, if you haven't taken a look at the bill from 1992, which created the OPA, and this is just to echo my support for 30236. Back then, when they put laws together, the legislature actually talked about what's the intent, and there was a big attachment to the bills. And one of the things that it says there is that it's felt that the public auditor, independent of the three branches of government, would provide the needed check and balance on the keeping of accounts and expenditures of funds of the government to ensure the highest quality accounting of public funds. It would also take the job of accounting for the public funds as far away from the realm of politics as is possible in the political world. That is the actual original intent of this bill. So I see that everything that's in the bill, 30236, is exactly carrying through with that, continuing to stake out the independent corners of the government and to put integrity into the process by ensuring that the stable of talent is going to be around and that there is enough funding to ensure that the public auditor can follow through with all of his charges in the statute, because there are many. That being said, one of the issues that has come up, and it's come up historically, is in the procurement law itself. And over time, the Supreme Court has interpreted that cases brought appealing from the public auditor are in the nature of complaints. And in the law, that takes a different life than it takes usually when you appeal a decision of an agency, you send up a writ, and it's not necessarily a complaint. Now, at the end of the day, they're getting to the same question, which is, what is the harm that is going to be resolved by the court, or what is the mistake that is going to be resolved by the court? But in getting to that, there is a body of law which starts to look very unique to Guam. And we had, in the last year or so, been asked by the Superior Court to review this question. And we spent about a year litigating this question about whether it should be a complaint or it should be a petition for judicial review. And it's a good idea, and we've tossed around a couple of ideas internally about how to remedy this situation, which is continue to follow the line, because if you go down the path of whether it's a complaint or whether it's a petition for judicial review, when you have a complaint, it becomes much more adversarial. Now you have discovery rules, you have rules of procedure that kick into play that wouldn't normally come into the petition for judicial review. And when you take a step back, what it actually does, if it's going to be carried through under the complaint, then you have a relitigation of the issues. Because if you have discovery, you're entitled to look into the facts and look for what's relevant for your case. So it puts actually in the situation that we're in the case that we're handled, it actually makes the OPA take more of a, instead of a stance behind the decision, the OPA is now being made to answer like it's one of the parties. And I think that's where, if I can explain it, try to explain it in more simple terms, by making it a complaint, the OPA becomes one of the actual parties to the litigation, and then the OPA is also being sued directly. And that's the other thing that's different, because the OPA doesn't control the purse, but the OPA is now being brought into the litigation as if they are able to speak for the sums that are under contention. So the Superior Court has actually resolved that and said, no, it still remains a petition for, a complaint. But it does cause some issues in the handling of the case which are unique to Guam and tends to turn up in litigation. So I believe that's what the public auditor would like me to relay to you. And I know it sounds a little technical, so I'm happy to answer any other questions on this issue.
Thank you very much, Mr. McDonald. We'll now open the floor to questions, beginning with Speaker Terlahi. I'm sorry, the sponsor of the bill, Senator Brown.
Thank you very much, Madam Chair, and certainly to the Speaker. I appreciate all of you providing testimony, certainly to have the first and reminding me that, Doris Brooks, gosh, since 2000. And certainly also Douglas Moyning with your years also of serving as our counsel here at the Guam Legislature for a number of years, and of course being our first elected Attorney General. I just want to ask, I mean, I appreciate the positive testimony. I think ultimately we have the very same idea of wanting to ensure the autonomy and the viability of the Office of Public Auditor. And certainly the recommendation by former Attorney General Douglas Moylan, I think we can probably look at it, where's the medium ground, because we did discuss this issue with the Office of the Public Auditor, and Public Auditor B.J. Cruz did relay. He did not want to have a full-time legal arm. He would prefer that it actually, in his position, and certainly Public Auditor Cruz, you certainly could elaborate on this with regards to having, as to why we came up with a medium proposal of having an Assistant Attorney General that could work with a public auditor. But the public auditor also relayed that he did not want to have a full-time legal counsel, that if the Attorney General had other assignments as well, if there was no assignments by the Attorney General's office or his office, that Attorney General would still be able to perform other duties as well to the office. Our main concern is wanting to ensure that these issues, I mean, as government goes, revenues dip, issues come up and down. We just want to make sure there's consistency with regards to ensuring that public funds are properly spent. And we've seen many examples over the years simply because we've been around long enough where that has not always been the case. And as I mentioned earlier, while the Office of the Public Auditor continues to provide these audit reports, when there are issues that do come up, you know, dust collects and life goes on, and that really should not be. The intent is to address corrective action. If it's simply that, if, you know, department or agency is not following proper procedures, they need to enhance or improve that, I'm sure you properly advise them. The following year, and I know certainly the time in some of my previous positions with Public Auditor Brooks, she would come on an annual basis and go over the findings with our department and with our key division heads to say, well, you know, this is good, or maybe you need to improve, and then the following year still come back and say, okay, well, you've corrected this, or by the way, we need to improve on this, where there's no negative intent to abuse public resource, but simply your process or procedures. But if there is intent, and there's misuse, because, you know, over time, people are able to create their own little kingdoms. I mean, they have their little corners of government that they're able to facilitate. Could be the hiring, could be contracts, could be favors, who knows, the list can go on. And we simply want to have a mechanism in place that if that's determined to be the case, that everyone knows, all public officials in government know that there'll be consequences to that, so that we have some confidence. Because as you mentioned, you know, and you reconfirmed to me, Attorney General Moylan, that yes, there was a time we had less than $500 million of running this government, and in 14 to 15 years, it's exploded in terms of the size and the amount of money in our government. So I'm open to language, and I just wanted to ask Public Auditor Cruz if you could elaborate with regards to the legal arm, so that there is a mechanism and a direct relationship, because there's such a tendency, and I understand the Office of the Attorney General has to address all kinds of crimes. Certainly we want to see them do more with regards to crimes in our community that continue to build and the drug problems that we're facing. But at the same time, there's still a need for consistency with regards to this issue in government. So if I can ask you, Public Auditor Cruz, if you could provide your input with regards to this issue.
Thank you very much, Senator. Yes, that's why I appreciated the fact that the way that the bill is written, it would be a memorandum of understanding that I would have, that the Office of Public Accountability would have with the Attorney General. Because it would be nice to have an Attorney General, an Assistant Attorney General who I could go to and say, I've issued this audit and I need for you to follow it up, as opposed to sending it to the General and it trying to find someone over there that is willing to look at it. So yes, it'd be nice to have somebody that's over there that would be funded by the office to be able to pursue that and prosecute that. But as I mentioned to you when we spoke, I don't want to be doing prosecution. I don't want to be doing prosecution. I think that should stay at the Attorney General's office. And Mr. McDonald serves as legal counsel, and he's the hearing officer in the office. He hears cases when I need him, when I recuse myself from certain cases. And so it would, I don't want to have a conflict of interest where, I mean, right now, in the way that Ms. McDonald was explaining it earlier, when the government is appealing a decision issued by the office, It is GSA versus the Office of Public Accountability. And GSA is represented by the Attorney General's office, and Mr. McDonald is the one that goes over and represents me in court. And so I don't want to have that. I don't want to have too many attorneys that are in conflict with each other. But I want to keep my procurement and my operations of the office separate completely from that. But the prosecution of our findings would be something that I would work out with whoever the Attorney General is, to have an understanding that, like I think at one point when Public Works was paying for an attorney at the Attorney General's office. And when they weren't being used, they were used for other things. And so I wouldn't mind that, but at least I know that if the Office of Public Accountability comes up with an issue that I need immediate action on, I can say, I want you to look at this and see whether or not this can be prosecuted and not have to go through the whole thing. So that's why I'm very happy with the memorandum of understanding, and I would work it out with whoever the new general is going to be.
And you could certainly, as you mentioned, work out that language that would meet the very objectives of what you relayed. And certainly the advantage to the Office of the Attorney General is that funds from the Office of Public Accountability would fund that, so that there would not be a void or impact to the Office of the Attorney General with other obligations. But we have some comfort level, as Public Auditor B.J. Cruz relayed, to have that. If the opportunity is there, you have an interest, or your findings of your audit determine a need to do that, that you have those resources available to relay those concerns, which I think is what would all give us some comfort. And that process should go on year-round, no matter who holds our respective offices here, so that, as I mentioned, I think our public needs to have some sense of confidence in the operations of our government, rather than we hear the problem, we hear what has occurred, and then no action is taken. And I think that's what erodes our sense of confidence in public office and also the work that's being done by our government. I don't have any further questions. I appreciate, Director Burns, also for you relaying your concern with regards to the work that's also being done by your people. I think critical positions in the government need to be addressed. I'm not an advocate for continued increase of cost of government. I'm bothered by it. I'm coming back out of a time warp at a time now when we cannot spend money in this legislature fast enough. That bothers me. But there are critical areas where I think that there's direct interface for the public that we need to address, certainly with regards to public safety, and other critical areas with regards to public accountability and corruption in this government that I'm very concerned about and I'm advocating for. It's in those areas I'm very supportive of providing, because in this case, we're not talking millions of dollars. We're probably talking maybe another $500,000 or more, just a little more, to accommodate the issues with regards to the pay increases for your auditors, to provide funding for your MOU agreement with the Office of the Attorney General. It's really not an insurmountable amount compared to what we are spending with other operations in this government. So again, I thank all of you, including Mr. Linsangan from the private sector, of coming and providing your testimony and relaying your issues. Mr. McDonald, to your auditors, thank you. Thank you very much, Madam Chair.
Thank you, Senator Brown. Speaker Terlahi.
Thank you, Madam Chair, and thank you to all of you who have come to testify today. I support the intent of this bill. Of course, anything that's going to make our ability to prosecute, abuse of discretion or abuse of financial authority in the government, I support. And if it takes, making, boosting up the staff, of course, I support that, and providing counsel as appropriate, I support that. So please don't take any offense from my questions, but I do have some questions, just because there is a big, I think all of you are being very nice maybe about it, but I want to just ask kind of bluntly. So I'm just going to start with the legal one, since the former Attorney General Moylan is here. I'm glad, because so right now the auditors mandate is to report to the Attorney General for prosecution of violations of law regarding violations coming to the auditor's attention regarding expenditure of funds and property of the government of Guam, including autonomous agencies, those pertaining to trust funds held by the government or such other civil or criminal action as the Attorney General may determine. Do you think that, so already that's supposed to be the mechanism, that they just have to refer it and the Attorney General is supposed to pick it up and take care of that, right? Prosecute that. But of course we know that Attorney Generals have discretion. So how can we impact that discretion? Can we impact that discretion by mandating that they assign one Attorney General over to this department? Agency or office? Or is there another way?
Thank you, Madam Speaker, for that question. I actually was thinking about that on the way over here and after reviewing this. The common law power of any public prosecutor or attorney general in Guam's case is, one of it is the discretion to prosecute. Whether it's good or bad, the public normally, and because the senators have made an elected office, every 4 years that person is put on the hot seat on whether he or she has done that. One of the quick and easy responses is if that has, in the eyes of the legislature, the chairperson or any senator in the committees feel that it has not been effectuated, you bring the AG in and specifically start asking that AG with the public auditor present, why didn't you do this? And because it's a political office and we can't ignore the fact that the AG is answerable to the electorate. So that would be like the quick and easy way of putting the individual on the spot and having him explain to you who he has to because you fund his operations. The second one would be create that requirement, like I mentioned, and before I came here, I spoke with some of my team in 2003 to 2006 about what they felt about this, and they came up with this idea because the Attorney General's office has already been told you must have a consumer protection division. In my opinion, the public accountability function, the government corruption function is arguably more important than a consumer protection division. Mandated that the Attorney General shall have a consumer protection division, and you will create, you would put a spur under the Attorney General's saddle, so to speak, that you will have attorneys in that division, you will have to provide investigators, and as I mentioned before, their most important resource is the Office of Public Accountability, the public auditor. And you could even put that in the statute. What I am concerned about, and as Attorney McDonald has pointed out, this is exactly the problem that you have when you put the public auditor in part of this judicial, their function is judicial. They're reviewing the actions of another agency, but as Mr. McDonald, Attorney McDonald is pointing out, you have a court system that's not sure what to do with it. I'm old enough as an attorney to remember the Civil Service Commission. I think it was Mr. Klitsky was one of the attorneys on that case. There was no procedural mechanism to go from the Civil Service Commission to the Superior Court. So they created that judicial mechanism by court proceedings. You know, judges says, okay, we'll give a 30-day rule. It'll be a petition for judicial review. But to have what I'm hearing from Attorney McDonald indicating that they actually have to get down and dirty as a litigant, and then you've got attorneys from all the government agencies that are getting involved, my goodness, the amount of wasted government resources that's created by that type of procedure that's being judicially created, where you senators, seeing the problem, could easily just write it in and just say that this is how the procedure will go. It sounds like there's a bit of confusion on what position the public auditor takes when you go upstairs. But for purposes of your question, Madam Speaker, is the discretion on whether or not an Attorney General chooses to prosecute criminally or civilly or decide to resolve the case out of court, so to speak, or not to prosecute it at all because there is not a case and the public auditor and the AG discuss it and decide, well, this isn't the case. That is part of the discretion that, unfortunately, we as a government have to rely upon the elected officials to properly do it. But again, you have extreme oversight authority to put that Attorney General on the hot spot, or any government official for that matter, on the hot spot for not doing their job. And there was another comment that I wish to submit. What I'm hearing is that they're having the complaint issue. The Attorney General, the second duty that we learn as Attorney Generals is that the duty of the AG is to create uniform legal policy. What is happening, and what I'm hearing is happening, is that you cannot let department heads determine what the legal policy is, whether we're going to litigate or not, and take, that's the kingdom building within the government, which the taxpayers ultimately pay for because it gets so inefficient when everybody's fighting among each other. So in the States, it normally comes down to when you have an Attorney General situation like this, you trust that person to control the government's litigation. And that is why the public auditor shouldn't be going and having to defend a position. They make a judicial ruling. That judicial ruling must be litigated by the parties, as in a superior court, and I'm speaking to the expert, one person away from me, the Supreme Court Justice Cruz himself. He is well aware and probably could assist on developing a procedural avenue that's more akin to what it should be than what it's beginning to morph into. Okay. Also, may I comment that we must be careful too, because the public auditor is a witness, can be a witness in a civil or criminal case, and you don't want to join them at the hip, because to a jury, and even potentially on an ethical basis, it could create a problem for an Attorney General being having the public auditor being an arm of the Attorney General, especially when you put him before a jury that's trying to balance the issues. Thank you.
All right, thank you. Yeah, so I too want to distinguish between what we're talking about here today. Already the public auditor has the authority in another part of the statute to hire at his discretion a private practice, attorney in private practice, or utilize the services of the services of the Attorney General. And this is in his auditing work. And I guess so right now, and over the years, they've hired private counsel. And then for the prosecution of crime, so that's hiring private counsel to advise them as they are doing their auditing scopes of duty. They also hire hearings officer to assist in the procurement, which is a totally separate, I don't even think that's foreseen in this, that much, in this bill. The procurement's a separate matter. They, and that issue that I think Chief Justice Cruz, former speaker and current public auditor, brought up about the procurement conflict or potential conflict, I think if that needs to be resolved, yes, that we are open to any suggestions. I would be open to remedying that if there are any suggestions. But for this part, I think you made it clear that the intent is to promote prosecution of audit findings, right? Or based on audit findings. And I very much support that. And so it looks great when the auditor and the Attorney General are in agreement and then they act cohesively. But when, we've seen cases where they haven't agreed, and I think I thought that's the case you were going to talk about, where they don't agree on prosecution of the case, then we are very much at the, subject to the discretion of the Attorney General in whether they're going to prosecute or not, or pursue civil litigation or penalties. The other part I wanted to talk about is I'm all for making sure that you have enough money to hire the correct staff and to be effective. All of that is fair, to discuss. Oh, sorry, if I could just go back to that prosecution. I agree with you. We do have power of oversight over, the auditors, the attorneys general, but we can't command discretion, right? On any of them. And that is the beauty, I think, in this elected office. And that what I like is that we have an auditor who is very much, I think, stood up to be independent. This office is independent in my view. The cries that it's not are very, I don't know, I'm not that sensitive to those because we are very much depending that the auditor's office is independent, has been independent all these years, never backed down, not vulnerable to somebody saying, oh, we're not gonna, give you your money, so please do the audit this way. I have never seen that. And I can't even imagine that with the people who we've had in the office. I mean, you're sitting right here, and I can't imagine that that's a real threat. And I'm praying that it never, ever can be, because you have the voice, and that's how you're going to do it. You're going to do it the same way you have been doing it all these years is, they don't respond to your audits, you call them out. If they don't respond to, these are crimes that should be prosecuted, you call them out. And you use your voice that way. And I think that's the beauty of the elected part of this office, is that you don't have to answer to anybody, really, except to the people of Guam, and that you should be vulnerable to no one. So this part about, somebody, an agency is going to affect audit findings, I've never seen that to be true, and I hope that's never, ever been a real issue. I mean, even if they don't pay you, issue the findings and say, they didn't pay us. And then, I don't know how you would pursue that, but I just don't see that to be equivalent, that an agency doesn't want to pay for their part of the audit until you change the findings. I mean, has that ever happened? Is that really a real threat here on Guam with our elected public auditors?
There have been occasions, and I do recall in my time where a finding we thought was going to go through, all of a sudden wasn't there, and this is not dealing in the time of Director Burns, but in previous times there have been, and that's the reason, the rationale why Speaker Cruz, Public Auditor Cruz, wants to control the funding to ensure that, and I do recall, I can't recall the details, but I do recall, calling up the auditor and saying, what happened here? I thought we were going this way. Now we're going this way. What's going on? Tell me. And it's because they were dealing with the agency, and the agency gave them this or that, and then they kind of mollified. It went from, how should I say, a material weakness to a significant deficiency. So it's the gradation of the finding that can be mollified,
Okay, maybe I misunderstood that. So you were talking only about external auditors, not those inside your office. Those are, can we say safely, the ones, your auditors are not vulnerable to that type of threat? Okay, external auditors, then I fully agree. Yeah, get the money from the autonomous agencies in advance, keep it, and so you can pay those external auditors. There's no risk of them not getting paid. All right, I have no objection with that part then. I just wanted to make clear, we're relying on the auditors to be the example of what every director can do. And I don't want any director to ever come before us because we suspect it, but we don't want to, we haven't heard them admit it. I mean, they admit it to us privately, I have to say that they are very much vulnerable to the release of their allotments and doing things because somebody else doesn't want them to do it, or things like that. And I just think we don't need directors like that, and we want our auditors to be the example of how you stand up to that kind of stuff. Yeah. And
Madam Speaker?
So can I ask, have you ever had allotments withheld? Has the OPA's office ever had allotments withheld? Because you're already exempt from allotment control. Okay. I just want to make sure. So that was already in statute, and that statute as written should be sufficient, but we can repeat it again. So the salary in the bill, so I understand your suggestion, Speaker Cruz, that we're going to adopt a temporary study, or a study that was done already temporarily while DOA works on its audit of all employees or all auditors. But on the bill, it says that, first of all, we're going to raise the salaries of the OPA and make them commensurate with the highest salary paid by autonomous agencies or semi or line agencies. The highest salaries, that's one. Second, it says that they will still be eligible for additional certification pay, 10%, which I think they're already entitled to. And then a 10% pay differential in addition. Are they entitled to that pay differential right now?
The only ones that are entitled to the 10% or the 15% are the ones that have certifications, if they're CPAs or they're CGFMs, and my ones don't. Well, one of my ones now has a
certification?
CFI.
Okay, so yeah, so we've already adopted the certification pay. That will continue. This asks for a 10% differential on top of the certification.
I'm not sure, but I think the way that we intended that was that the Office of Public Accountability auditors, the accountability auditors, would have that certification pay, but if they, to try to make sure that they're not poached and taken away,
Yes.
I think the way that it's written in the bill is that if they go to one of the agencies, then they lose that
Yes.
ability to be certified.
They use that differential pay.
Yeah, as the
And maybe there's-
incentive to stay at the Office of Public Accountability.
Yes. I know we're trying to, well, I've been, discussing with the Attorney General's office, the same thing for prosecutors, right? They're hard to recruit prosecutors, hard to retain prosecutors. I think they have a special type of role versus the other civil attorneys and other attorneys there at the Attorney General's office. But yeah, so we've suggested that they also work with DOA to rectify these situations, right? Where not all auditors are doing the same work as you have described, and you have described, Mr. Byrne. And so I would like equity, but to just try to meet these autonomous agencies it seems such a blanket approach as opposed to, I don't know, do you have any other alternatives, Mr. Byrne, that you're looking at for when you're doing this pay study that you're currently undertaking? Like, can we just influence the autonomous agency descriptions and our own description in the line agencies to show the distinction and the importance of the work that you are doing?
Thank you, Madam Speaker. We are actually, as you know, looking at the government of Guam employees who are in the general pay plan. It wasn't intended that we were going to separately look at accountants, but I did mention in the DOA budget hearing the difficulty that we had, that has been referred to today, in retaining qualified accountants. And I have a few also that have certification pay because they are qualified accountants, but not all of them, not everybody at DOA does. So we are looking at it. We haven't reached our conclusion yet as to quite how to deal with it, but by way of example, last week I had a request from an autonomous agency with respect to it was an accountant, but they called it, and this will help you to decide which agency this was, a utility accountant. To me, there is no distinction between a utility accountant or a DOA accountant or an OPA accountant. So we are looking at this, but we haven't yet reached our conclusions on it.
All right, thank you. But I do understand your issue. This is an issue faced by several agencies right now, maybe all of them, right? The risk of their trained staff, after years of training, being recruited to autonomous agencies. And then my final note is just on this, the 0.25% budget. I understand the intent of that, and I don't have a real objection, but I was looking at, so BBMR provided a fiscal note, and they laid out over the years. So really, this year, you're only $100,000 short of what that would have been. So that's great. I think we did good, right? So I'm taking credit for the legislature, but it's getting better. So we're close this year to that 0.25%. But ironically, this appropriation, well, no, it's actually, yeah, it was $200,000 higher than the request. But over the years, I thought, when you really look at it, it hasn't departed significantly. It's been since 2017, 18, and 19, they were the same, despite that 2018 tax cuts that we had to deal with. The budget for the OPA stayed the same. 2019, it went down just a little, from 1.3 to 1.2. Then it stayed the same 2020. So yeah, I can see it. I don't know, I don't really like formulas. I rather you just justify what the needs are, and I think, like as demonstrated in FY22, the legislature was able to increase even from the requested amount to a better amount. All right, that's all I wanted to say. Thank you, Madam Chair, and again, thank you, Public Auditor. Thank you, former Public Auditor and former Attorney General, and to the auditor staff and attorneys, and Mr. Byrne, Sidus Masi.
Sidus Masi, Madam Speaker. Senator Taitague.
Sidus Masi, Madam Chair. Yeah, I'm like, this is an all-star panel right now, looking at a lot of institutional knowledge sitting in front of us. So I really appreciate you coming out, taking the time out to provide comments regarding this legislation. It just goes to remind me what I did in January of this year by sending a letter to the Office of Attorney General based on an OPA report, Report 2103 and 2109 regarding the Port Authority and what was going on there, the indiscretions that were going on. And I was hoping that just with this report alone, I mean, it was in the media, that the Attorney General's office would have caught wind of this and acted upon it, which they didn't. So I took the initiative and sent a letter in January of this year to the Attorney General's office to address these issues. And that was January of this year. And I still haven't, after 3 follow-ups, you know, like, they still have not answered my letter regarding this. So you can see how important this legislation, I think, is to myself, because I don't think it should be us as a legislature sending these letters to the Attorney General to act on OPA reports that are clearly, you know, in violation of spending money, as well as other indiscretions. You know, I'm one of those senators, you know, I don't know if there's very many of us that read the OPA reports. I read every single one that comes out, because this is where I can find out what's happening, like you said, Mr. Moylan, regarding, you know, follow the money. Mm-hmm. Yeah, I do. That's why everyone says, how do you come up with these questions? Well, if you read the OPA report, you'll see there are many questions in there that need to be answered. Or ask them, why did this happen? Or why is this report stating that you spent over this amount? This office is very, very important. And I think the beginnings, the onstart, when it was opened in 1992, that it was mentioned, Attorney McDonald, that it was created, right, separate and apart. I don't think anyone is arguing that. You know, it stands on its own. But I think that the funding source back then was not equal to the amount of work that's required from this office from the get-go, from the very beginning of this written legislation that created the OPA's office. And I think what we're trying to do is to get to that level. As important as this office is, I think we should do everything possible to support it. And this legislation is the beginning. And having all you here with your comments and suggestions is going to be very helpful to make it stronger so that the people of Guam can rest assured that their hard-earned tax-paying money is spent correctly. It's not wasted. The only real question I have with the OPA's office, Speaker Cruz, is you gave us some amendments here. I'll try and make this as short as I can, but you gave us some amendments here, Section 2, 1908B2, Chapter 19. And then when that's on page 1, okay. Okay, I see the difference in that according to the current legislation on the change. But the second page, page 2, where it says Section 3, a new 1911 is hereby added to Chapter 19, Title 1, Guam Code Annotated. And then on page 3, it's almost the same thing. Can you kind of explain what's the difference between these two?
Yes, Senator. If you go to the, I also included a chart on the back of the third page.
Yes, right after the third page. Yeah, page 4.
If you look at it, depending on which one you use, the amount that's appropriated to the office could be different.
Okay.
Except for this year, which for some reason, the projected general fund revenue is somehow equal to the total general revenue available for appropriation.
Okay, so it's two different samples based on that.
Yeah, it's two different numbers, because in the past, we used to have the general fund, and then we take the bond monies out and the tax provision out, and then get to, then we would net a different number.
I see.
But for some reason this year, in this year's budget, it's showing the same number. But as you can see from the from previous years, the amount appropriated to the office would have been different depending on whether or not it's just general fund or general fund available for appropriation.
Right,
Okay?
but I'm looking
But
at...
I'm leaving it up to you guys to
Yeah.
to decide which one it is. That's why I gave you both options there.
Okay,
But I
yeah.
showed you how much that difference would be.
Right, I see that. And you've also addressed in your testimony, one of the concerns I had, one of the questions I had with regards to what if we don't meet that, you know? It's not going to be raining money very long here with federal funding coming in, and so I was wondering how you would be able to accommodate if we go below what your normal 1.7 would be.
That's why in my testimony I said we would have, we could write it in that
Right. And
the
the
minimum would be 1.75.
Yeah, and the recommendation is 1.7 million, so I appreciate that. But I didn't really see that in the legislation. What part of the bill would that section be located at? Would you incorporate that language? Would that be
Yeah, in Section 3.
second? Would that be Section 3 on
Yeah.
page 4?
Yeah, we could add,
Okay.
we would just add another line that in the event that the amount went down, that the minimum would be 1.75.
Okay, thank you. And I know we have another bill coming up, so I don't want to belabor this any longer, except, Mr. Moylan, Attorney Moylan, I talked about the issue that I had with the port. I mean, I wouldn't have to do this legislation or write a letter like this if they just did their job.
There's a way to deal with that, Senator.
Yeah, this situation. So my question would be, how did you work it out with, then Public Auditor Doris?
We had a great public auditor.
Relationship?
It's, again, that trust you put in the government officials, the trust
Yeah.
you put in the electorate, and then the track record and so forth. Senators, though, I have a suggestion that you may want to consider. For the situation where the public auditor feels that the Attorney General is not acting upon something to protect the taxpayers, you can put a statute that requires that the Attorney General, at the triggered by the public auditor, a request by the public auditor to issue a report on their audit that is public document that would have to address the civil aspect of it, the criminal aspect of it, so the public will see that what is the Attorney General doing with a duly issued report by the public auditor.
Thank you. Yeah.
That is not infringing upon his prosecutorial authority, his duty as a public prosecutor and as a civil
Well,
protector.
I actually had another bill that provided a fine if they didn't answer our questions from the public, from the Attorney General's office. That bill had a public hearing. You know, we would fine him if he doesn't give an answer within 30 days. You know, of course, they came and testified against it. But yes, I'd like to hear from you too, Doris. Go ahead, Doris.
I agree with Attorney General Moylan, because I recall during my time, there was even one audit that we were asked by the Attorney General to do. And when we gave it to them, they did nothing with it. And then there was another audit on Public Works that after it was issued, I got so many hotline tips. And I went to the Attorney General's office, and again, they did nothing with it.
I think it's important to put enforcement in this. I mean, the kind of work that the public auditor does with all the accountants that do their forensic investigation is enough for the attorneys to do something and move forward to.
And may I inquire, Madam, was that with my office?
No.
Yeah, just to clarify that. Because somebody would have,
That wasn't your
somebody's
office.
head would have rolled if that
Okay, we'll make that clear. That wasn't
No,
when you were in office.
But
Okay, we got that.
I completely agree with your concern, but
Okay.
if the public auditor was to issue again, statutory requirement, instead of fining somebody, but make a statutory requirement that upon triggering by the public auditor, that they are requesting pursuant to this statute a report which can be issued within 60 days or whatever the legislature would decide, that would review the aspects, the criminal aspects, the civil aspects, and just the viability of the government's interest in it.
Right. I agree with that. I truly believe that if we're going to put out legislation that it needs enforcement, you know, it needs some teeth behind it.
Yes.
And a lot of times there is no teeth behind these bills. You know, you just say you got to do it, and next thing you know they haven't done it, or like you have to deposit this refund into this account and it's not been done. Where's the teeth to it? Mm-hmm. So yeah, I like my other bill that requires him $100 from the Attorney General out of his personal pocket.
If he doesn't issue that report.
If he doesn't, yeah. So then again, I wanted, again, thank you so much, everyone who's here, Director Burns, for being here as well. I know you've worked very closely with Public Auditor on the salary concerns, and I hope that could be addressed too with providing the funding that he needs to implement that, as well as you, Attorney McDonald. Thank you so much for being here. Okay, and everyone, Moylan, and of course, Doris, it's always a pleasure. A Southern girl in the house. Thank you. And of course, my good friend, Vince, thank you so much for being here too. Thank you for all your hard work. Senator Shelton, I'm done.
Thank you, Senator Taitague. Senator Nelson.
Perhaps I just have one question for Director Byrne. Director Byrne, you gave a lengthy explanation, but it wasn't certain to me if you were in support of this bill or not. Are you in support of this bill?
I mean, generally, yes. I mean,
Okay.
I'm certainly in support of an independent public auditor, and if that is what this bill actually achieves, yes. I'm a little concerned about some of the mechanics of it, but as I said, independence is paramount,
Yes,
and
some
if that's
adjustments.
the goal, that's fine.
Okay, thank you very much. You know, if we were challenging in basketball, you guys would definitely win compared the lineup and roster you have on your team compared to this side with your experience and knowledge. Thank you very much. I thank you for your testimonies. I hope to see this measure passed with the amendments aforementioned. Speaker, do you have?
Mr. Byrne wasn't here when I had my budget hearing, but at my budget hearing, you remember that I said it's imperative that the office, the Department of Administration be properly funded to do its accounting functions. And the fact that they currently, I think, don't have a controller.
No, they mentioned one last time.
We have a controller, but we don't have a financial manager.
A finance. So they also, we all need to have some kind of comparative pay scale throughout the government. Maybe General Moreland's suggestion of the attorney pay scale, that is the pay scale throughout for everybody. Because if Department of Administration doesn't have sufficient and adequate accountants and people, no matter how much I scream, it's not going to, the audit's not going to come out in time because they don't have the number of people. And even with the same thing with Department of Administration, that they're not going to be able to unless they have the competent staff. But we're all competing against autonomous agencies that pay $15,000, $20,000 more than ours. And in the one case that was mentioned by Doris, went from 49 to 62. My staff needs a master's degree to get to the 62. And the one that went from my office to GPA did not. And so there's got to be something, but I think it's got to be government-wide. That's why I said it has to be empirical and scientifically designed to cover everybody, because unless we all rise, we're just all going to be bobbing separately. And so I want to make sure that the Department of Administration is properly funded and their people. And just the other day, I was going into the bank and I ran into a senior person from Revenue and Taxation, and he said, hey, you know, I agree with your position about losing people to the autonomous agencies. A lot of the problem that they're having up at Revenue and Taxation is the fact that their senior people are going to go to the autonomous agencies also because of better pay. And if we don't have the people that are collecting the taxes, you're not going to fund all the rest of us. So we're all interlinked. And so we have to find something that's going to work for all of us. And I hope that, and I'm convinced that Mr. Byrne and I working together can design something like that and present it to you. But in the interim, if you just please give me the authorization to give my threes just a little bit of hope that there is something at the end of this. Thank you.
Thank you, Speaker. That's all I have, Madam Chair.
Thank you very much, Senator Nelson. Speaker Terlahi has one more question for the panel.
Yes. So, Mr. Byrne, in follow-up to that discussion, so when the Department of Administration does these pay scale studies or the market studies, don't they incorporate the autonomous agency pay as part of the market that they're comparing Guam or our line agencies pays to? So if they did that, why did the pay end up still so low versus the autonomous agencies? And will you be able to do that in the upcoming study?
Thank you. Well, in the pay studies that we've done so far, it really hasn't applied because for instance, for the law enforcement pay study, we included all the autonomous agencies that have law enforcement except the port because they were looked at separately. We are, of course, as I mentioned, looking at the general pay plan. Yes, we can certainly, or we will certainly look at the autonomous agencies, but our data pool the bigger amount of the data is comparable positions, in particular on the mainland, because we also get people leaving and going to the mainland. Of course, that's a much bigger pool of data, and therefore, in any comparison, it figures much more deeply. But we will certainly look at the autonomous agencies.
Speaker Cruz or Public Auditor Doris, in your years, have you thought of any other solution to that besides on this side adjusting? I know I heard it discussed, but I'm not sure if any concrete solution was ever discussed. I think they tried to do that with posts to make all the law enforcement salaries across even the autonomous agencies more in line with each other, but I don't think that actually occurred. Do you know any other solution?
We just have to get the autonomous agencies to realize that though the legislature gave them the authority in the Searle studies to do their own salary scale, that they shouldn't do anything that's going to completely throw the whole system off. I understand that they're revenue generating and they figure they can pay more, but when it completely undermines the rest of the government, it really shouldn't be. And especially if it's in a position that the people are all the same, I mean, they're doing all the same work. The accountants at the utilities, whether or not you have utility accounting, it's still the same thing. But if it was an engineer, there aren't engineers in other departments except that it's up there, or or water engineers, or those are the real technical people that are supposed to be should be getting different pay from everybody else. But all the other positions, really, we should have one salary scale for the entire government.
Thank you.
If I could just
Yes.
also add, because I remember when the Searle study came out, and when they implemented, they only implemented it at the 25% percentile. They didn't fully implement it, because if they had fully implemented, the cost would have been tremendous. And the Searle study was very different from the Hayes study. Okay, different folks, strokes for different folks, type of thing. And ever since then, that's where we have seen this siphoning since when they were allowed that, and it's been nonstop ever since. And I think, as Speaker Cruz said, it needs to be uniform throughout the government, with certain exemptions. And one other thing that they did, in order to implement this, they determined that, quote, everyone was technical. Therefore, they were allowed to be given this higher implementation. And we've been, DOA, OPA, and has been suffering ever since, trying to play catch-up. It's always we're trying to play catch-up, not to meet, just to, not to exceed, just to play catch-up to what they're trying to do. All right.
Madam Speaker, and I would say also that that is the way to undermine the public auditor. They have the funds, and the public auditor's audits are normally, you see a lot of the scrutiny needed of those autonomous agencies. In my time, it was the airport, it was the ones that were generating their own money that the public auditor, Brooks, was focusing upon the abuse that was going on over there. If they can raise these salaries, and knowing that you cannot get these type of people easily, they undermine the autonomy and the ability of the law enforcement, well, this quasi-law enforcement type of audit that would be done. So there is an aspect of the government undermining another department by bumping its salaries up, knowing that they're going to be pulling these auditors that are auditing them. But I'll submit like that. There's something in there.
Thank you very much. Thank you to the panel for being here today. Senator Brown, would you like to make a closing statement?
No, I just want to thank everyone. I appreciate all your testimony and your input. I'm hopeful that we will be able to get this legislation through this term. And I know there are bigger issues, broader issues with regards to auditors throughout the government of Guam, but I certainly hear the concern raised by Auditor B.J. Cruz with regards, our public auditor B.J. Cruz with regards to addressing the more immediate need. I've always been of the position, and in the years I've been in government, I've always wanted to make sure that the side of the table that the public interest is represented should be capable, if not better, than the other side. And the other side is the external interest that the government has to deal with. I want to make sure that we're equipped to do what we need to do to protect the public interest, and not the big money out there or those that are trying to get the interests of the government and benefit at the government at the expense of our people. And certainly I think this is one very important way to address it. I want to ensure that all public officials are accountable, no matter what position they hold in this government. And I think if people understand our community, and more importantly, our public officials that work for this community, that they will be held accountable in terms of their job performance and what they do on behalf of the people, I think we'll have less issues moving forward. And I think that's ultimately what I would like to see, and I think many of us would like to see in our community. So again, thank all of you for your time this afternoon with regards to the testimony and the input you provided to this bill. Thank you very much, Madam Chair.
Sedius Masi, Senator Brown, there being no additional individuals to testify on Bill number 302-36 COR, the committee will receive testimony for the next few days. For the acceptance of any additional information or public testimony on the agenda item discussed, you may submit testimonies to the mailroom of the Guam Legislature or through email at senatorjoe.s.augustin@gmail.com. Sedius Masi, we will now take a brief recess to turn over to Bill number 310-36 LS. Thank you again to our esteemed panel. Sedius Masi.
Sedius Masi.
My name is Vince Wings. I actually work with the and I work before she hired.
Bonus and Hafaday, the Committee on General Government Operations, Appropriations, and Housing is back from recess. We are now on Bill number 310-36LS. Introduced by Joe S. Agustin, Telena Cruz Nelson, Amanda L. Shelton, Tina Rose Muña Barnes. An act to amend subsection D to section 58D103, amend subsection B of section 58D104, amend section 58D108, and amend section 58D109, all of chapter 58D, Division 5, Title 5, Guam Code Annotated, all to facilitate the financing of an education facility. The bill was introduced by Senator Joe S. Agustin, and I will read his statement. This bill is introduced by the request of the Guam Economic Development Authority to ensure that the government of Guam will continue to carry out its duty and move forward with the construction of the Simon Sanchez High School with the best possible savings. Bill 310 provides the Guam Economic Development Authority the necessary tools to ensure that the Simon Sanchez High School revenue bond is secured so we can move forward with construction of the new facility. The proposed amendments on the Simon Sanchez High School revenue bond will allow GIDA to be an issuing entity of the lease revenue bond, which will benefit the government of Guam with the lowest possible cost and interest savings rate. Also, this measure identifies the increase of the construction cost of the educational facility, which reflects the increase in GDOE's architectural and engineering design. Colleagues, it is right and just that we support this measure as it puts our children at stake. The Simon Sanchez High School facility is deteriorating, overcrowded, and outdated. It is no longer providing students the safe learning environment that the Guam Department of Education continues to echo to our community. It has been decades of waiting for the students of Simon Sanchez High School. We cannot let them wait another decade for a safe and proper educational facility. Let us come together for the children of Guam, as they will be our leaders in the future. I look forward to hearing testimonies and suggestions on this measure. Seduus Maasi. Again, that was a statement from the sponsor, Senator Joe S. Agustin. I'd like to recognize again my colleagues who are with us, Senator Nelson, Speaker Therese Terlahi, Senator Brown, and Senator Taitague. Seduus Maasi. Now we will begin testimony. From GIDA, today we have Melanie Mendiola and Tina Garcia.
Thank you, Madam Chair. If it's all right, GIDA would like to defer to GDOE to provide testimony first to give a sense of the project for the committee.
Sure. Thank you very much. We have from the Board of Education, Mrs. Maria Gutierrez and Superintendent John Fernandez.
Half a day, senators. I like that. Oh, women up there. Women power, okay. My name is Maria Gutierrez. I am the chair of the facilities under the Board of Education. I'm here this afternoon not only for the board, but for myself to support the bill. Senators, I have the students that are supposed to be here, but because they're attending summer school, unfortunately, we ask that they be excused, but they are preparing a written testimony, and then some of them are watching us live because I told them to start since 2 o'clock. I just want to remind you, they're also voters. They have registered, okay, and their parents are also watching us. You know, I was on this board when this Simon Sanchez started. And I was sitting at UOG during a graduation of Simon Sanchez when an administration, not the current, said, you will have a new Simon Sanchez in 4 years. Well, it's 8 years. But I want to go back to the senators that were there when they gave DOE the authority to handle the procurement. And I won't forget that, because Senator Nelson and I had fun that day. I want to thank all of you, the sponsors, and even those that are not sponsors, because this is really needed. It's for, I hear Senator Shelton saying, for our students. Yes, our students. They need that facilities. The northern people need that. I hear, people saying, oh, that Ukudu is nice, Southern High School is nice, but what about that Simon Sanchez? There's 1,600 students there. So I want to encourage you, and I beg you, I usually don't like to beg, to please get this bill passed. Time is moving fast, cost is going up, and our children from the Simon Sanchez needs a better facility. Unfortunately, I was looking forward at the time when they said, Simon Sanchez, you have a new facility, that my granddaughter, class of 22, would have graduated from there. I have a great-grandson. He won't be able to graduate from there because if we're just going to start this. So on behalf of the student of Simon Sanchez, please support this bill and pass. The governor told the graduates of class of 2022 about the bill. The parents were so excited. The incoming freshmen, sophomore and juniors and seniors are so excited also. So let's not disappoint them. We're ready to do the groundbreaking and invite each and every one of you. Although Mr. Fernandez will not be here to cut the ribbon or even to turn the dirt, but I know that he will be following this up with all of us. So it's our obligation as adults to give our kids the best facilities, and the Simon Sanchez needs that new facilities. My children that went to that school are now grandparents and great-grandparents. So as me will be the great-great-great-grandparents. So I know how it is to go into the school and their kids are afraid whether something will fall down. DOE is doing the best with what they have to make sure that our children at Simon Sanchez are safe. The two administrators on this side, on the left-hand side, are doing the best. The teachers and the staff. So please, I urge you, on behalf of the students of Simon Sanchez, to support the bill, pass it on your next session, no questions. Thank you, and I'll turn this over to Superintendent Fernandez. I'm here with him because it's his last day, and he started with me, so I want to make sure that he gives his last testimony for the Simon Sanchez. Si Dios más, buenos días.
Hafa members of the committee, and thank you for, once again, for an opportunity to testify before you today. Let me just recognize that in the room as well, we have Simon Sanchez High School Principal Carla Mesnayan, as well as Assistant Principal Melvin Fononia. So they're here. They've been real strong partners in the design process and very eager to see us move to the next stage. I did submit written testimony, and I'll go over it quickly, but I just wanted to, I did want to remind the committee that it was in 2018 when the responsibility for the school was given to DOE, and once that was done in 2018, we couldn't yet start right away. We actually had to wait for the protest to be dismissed or resolved at the OPA's office, which was done towards the end of 2018. So in 2019, I believe in March, we were able to award the land surveying component, the initial component, to Dueñas Camacho Associates, who then did the land survey. That was basically phase one, did the land survey work on Simon Sanchez High School and completed that work toward the end of the summer of 2019. We were wanting to move directly into the design. I know Senator Nelson remembers that we had to bridge the funding gap to make sure that the design had sufficient funding, but we were able to get to the, through that process so that by the beginning of 2020, we issued the solicitation for the design work. Unfortunately, because of the pandemic, it did impact the timeline for going through that solicitation process, receiving the proposals, evaluating, and then negotiating a contract. But eventually, we were able to award the design work to Taniguchi Ruth and Makio Architects, TRMA, towards around September, October of 2020, and that's when the design work began. So we did estimate the 12 to 18 month period of design of the A&E work. TRMA worked very closely with the Simon Sanchez stakeholders. They've had regular meetings since the beginning to go over the information, the needs that the school had, and then go through the various iterations of design to get to where we are today in June of 2022. And where we are today with that is that the design is at 90%. And so right now, that puts us in place to begin the next final phase 3, which is soliciting for the financing and construction of the school. And so that's really where we want to get to, with design near completion, start to bid out and then award a contract so that we can start the construction of the new school. So we're here to testify in favor of Bill 310-36. This provides an opportunity for the Guam Economic Development Administration to work with the GDOE and its contractor to ensure sufficient and cost-effective financing for the construction of a new Simon Sanchez High School. Under current law, funding for the new school is restricted to a yearly pledge of no more than $5.1 million coming from the Territorial Educational Facilities Fund that would be used to pay annual lease payments for a 30-year term, which is basically a leaseback arrangement for the new school. So with the proposed change, the law actually provides more flexibility to ensure that there is sufficient funding available to cover the updated costs of constructing a new high school. The funding for a new high school was originally set forth in Public Law 32-120, which was went into effect 8 years ago in 2014. Since then, several factors have come into play that affect the amount that should be set aside for a similar project in 2022. These factors, based on an analysis conducted by Taniguchi Ruth Makio Architects, include five key components. They include average yearly inflation of about 2.9% from 2014 to the present. Reflects the 1% increase in the business privilege tax that took effect in 2018. Estimates a 0.8% wage increase for 2022. And then the more significant components include a 40% increase in cost due to a pandemic, supply chain, H-2B labor, and military buildup issues, and then also an estimated cost escalation of about 8.7% for 2023, which is when the anticipated work or expenses will be incurred. So what this means is that a project that would have cost $70 million in 2014, which is generally around what we anticipated back then, would be projected to cost over $136 million in 2022. So while we are currently working to refine the design to ensure that it is cost effective, but still meeting the needs of the Simon Sanchez community, it's clear that due to these factors, there does need to be more funding authorized than was envisioned in 2014, and the flexibility to achieve the lowest cost of capital working with GITA. And so Bill 310-36 would accomplish this goal. With the passage of this bill, we believe the legislature will address this funding issue and allow us to proceed to solicit for the financing and construction of a new Simon Sanchez High School. I mentioned that we completed the land survey work. I mentioned that as of earlier this week, TRMA submitted their 90% design work, and then we are at this point finalizing the solicitation package so that we can get the document ready to be published and publish it for bidders to begin submitting their proposals or their bids. The key piece, of course, is ensuring that we can certify sufficient funding for the project so that we can then get that procurement out when it's ready. And this is why we are here today to support a passage of this bill so that we can have that funding certification in hand as we begin the procurement process for the new school. Under our current projected calendar, once we begin the solicitation process, we still aim to award and break ground on the new school later this year. Of course, that assumes, hopefully, the expedited consideration and approval of this bill. We do want to thank the sponsors for the introduction of the bill, as well as the support and the anticipated support from the rest of the committee and other senators. I do want to thank the governor and lieutenant governor and the partner agencies. On the project, GITA, DPW, and Department of Land Management are partners that are identified in the law as helping to help us work through the solicitation process, but also, of course, with DOA and BBMR here to ensure that the financing is worked out as well. We appreciate that support, and I think emphasizes the importance of this project and getting it moving to a stage where stakeholders, especially the students, can start to see the ground moving, the ground breaking, and actual construction work beginning. So with the passage of this bill, we move one more critical step forward in making the new Simon Sanchez High School reality for our Shark community. And we thank you for your consideration, and that concludes my testimony. Siduos Mahasi.
Siduos Mahasi. We also have Mr. Lester Carlson from BBMR.
Thank you very much, Senator Shelton, members of the committee. If it's okay, can we do this as like a tag team thing? We practiced while we were waiting outside.
Sure. Please.
We collectively have input in the drafting of the bill. We worked with bond counsel to make sure that the verbiage to meet the issuer of the bonds, being the Guam Economic Development Authority, to take advantage of triple tax exempt status and then therefore lowering the cost of borrowing was included primarily in this bill. If you go through the bill, you'll note that the amounts that we were working with were the publicly available amounts that we had heard, that being $120 million and another $26 million for capitalized interest costs for the 2 years during which the school would be constructed, therefore coming up to $146 million. We're going to have to make some adjustments given the estimated cost of $136 million and the amounts that we are utilizing as on a not to exceed basis, the $12 million, that needs to be reassessed as well. It will go up. And the other component that's not here is insurance and maintenance. And that will, in my opinion, easily be over $2 million a year. So we're going to have to refine some of the numbers here to be able to kind of like be in better lockstep with the Department of Education. The repayment source is stated as any allowable or any lawfully available monies. So we would work with you guys to figure out, it was the TEF, property taxes, but I'm sure I can get concurrence from Mr. Byrne that the volatility of the receipt of property taxes and the monthly debt service need to be better aligned. And we probably need to look at something like BPT, which has a very, Mr. Byrne mentioned this yesterday, very reliable and not too much volatility in the monthly revenues. But it would be something that we would work out with you guys so that we could be able to get the cumulative amounts necessary after we do some more refining to better align the bill with the project costs. The striking of the prior pledge from TEFF was done to be able to better articulate the fact that we don't have a pledge anymore because that pledge would be insufficient. Let's start brand new. Let's collectively figure out what we want to do to make this work. And as the Mrs. Gutierrez said and Mr. Fernandez said, break ground this year.
Thank you, Director. For the record, my name is Melanie Mendiola. I'm the Administrator of the Guam Economic Development Authority. Joining me is our Public Finance Manager, Christina Garcia. And what I'd like to lend to Director Carlson's testimony today is a view into the current municipal market environment, which is experiencing quite a bit of volatility. The U.S. Treasury rate has risen by 75 basis points since January, so we were looking at near zero rates, so 0.25, 0.65, now well above 1%. All of this is being aimed at curbing inflation, which we are all very familiar with, and as our leaders, the rising cost the rising cost of living is something I'm sure you're very familiar with. That is having an impact on the municipal markets. So there is a bit of volatility. When we started to do some projections on this, we did look at a rate of up to 7.5%. This is part of the reason the rate at 7.5% gives sufficient cushion to deal with the market volatility. We've seen rates most recently right around the 5% range, and so this gives you comfort that we can go sell these bonds and not have to not be in a bad position where we have sufficient demand, but we don't have we're not able to meet the rate requirement of our investors, or rather, we're without investors because our rates are not aligned. The triple tax exempt status remains with GITA as the issuer, or the conduit issuer for that matter, and we can explain that more in depth if you'd like, if you have questions about that. But overall, GITA is in support of this bill. We are in support of the Guam Department of Education in all of their planning. GITA has partnered with GDOE in the rebuilding of JFK, of Ukadu, Tizan High, and a number of other smaller school projects. And so we're very happy to support them in this initiative. Everything that Superintendent Fernandez said rings 100% true with regard to the rising costs of labor, of materials, and other factors that have driven the cost of what was originally a $60 or $70 million project up. Add to that the volatility of the municipal market, ongoing Ukraine conflict, and unsure inflation hedging measures being taken on by the Biden administration. For all of these reasons, we are entering into this with a little bit more uncertainty. Having said that, Gita will be here to support GDOE and do our best to save as much money for the people of Guam and for the ultimate beneficiaries, the students of Simon Sanchez. And so we're here on standby with any questions on the financing.
Thank you very much. Mr. Sabino Flores.
I'm primarily here to support the superintendent. Okay.
Thank you very much. Mr. Byrne?
Thank you. I'm not sure I'm really qualified to talk about this. My school was 100 years old when I went to it at the tender age of 13. I like to think that both it and I have aged gracefully since then. As Mr. Carlson said, my major concern is the impact and timing of cash flows. We are currently faced with a major payment on January the 3rd for one of these lease payments. So during the course of November and December, we're very well aware that we have to accumulate the funding in order to be able to pay that. So as Mr. Carlson says, it's preferable that we don't pay it out of the TEF, which comes from property taxes, which are payable in lump sums in February and April. And that kind of restricts us to payment then. We would rather that it was an equally a monthly payment that we can better account for, and that is what is being proposed by Mr. Carlson and Ms. Mendiola.
Thank you very much. Now we'll begin with questions. Speaker Terlaki. Senator Brown.
Thank you very much. I'm looking at this legislation, and I certainly appreciate the long term it's taken to address the construction or reconstruction or new building of Simon Sanchez High School. It's been a very long and winding road, but as I look at this legislation, the one thing that it takes out is the Guam legislature. And I understand the process of doing the lease back. We've done that for a number of schools, different from bond financing where we borrow and then we go out and contract a new construction, and that's the issue. Why is that an issue? I mean, it's not going to be a burdensome process unless you're at the port and takes 7 days to get your bond legislation passed, which I had to go through, but I don't understand. What's the issue? I mean, there are many schools on Guam that are far older than Simon Sanchez that no doubt we're going to have to address either refurbishing or rebuilding. I went to a couple of them. Price Elementary School was built in the 60s. Antalan, which used to be Barragata Junior High when I was there, was built in the 60s. I mean, Simon Sanchez, yes, granted, there's a lot of time and focus. I was there at DPW when the refurbishment and rebuilding of JFK was put in place, and that was executed. Granted, there were a few issues in the construction, but nevertheless, we completed that process. So what is the issue? I mean, it was turned over to DOE to do the procurement, and I appreciate the testimony of your board member, Maria Gutierrez, but it's trying to make it sound like somehow we have impeded the ability of DOE to move forward in procuring the construction for Simon Sanchez. So perhaps you have to fill in the blanks and clarify to me what I don't understand here.
Yeah, I'm not sure what you're referring to. I don't know if
I'm
my
looking
testimony...
at this legislation, this bill
Yeah.
that's before us today.
Well, what I'm saying is I'm not sure if my testimony...
Bill 310, do I have the right bill?
I said I'm not sure if my testimony gave the impression that the legislature was impeding the progress. I think what I described was the status of the project as it is, and then the need for a change to the law to address the current cost environment that we need to address.
I understand, but what are the primary crux of this bill? Essentially takes the legislature out of the process and grants the governor, be it this governor or any governor, I mean, for a 30-year period, it's quite substantive. The amount of money involved is substantive.
Correct.
Be it either through a lease back or if we were to authorize funding for a bond, as I mentioned, to procure the actual construction of a new facility. Where is the issue here that removing the legislature? Why is the legislature a hindrance to that then?
I can defer to our
Maybe I can ask
folks on the
Gita.
financing side.
That's all I see jumping out at this
Okay.
bill when I read the Finno-English. So can somebody clarify why is the legislature an issue? Because I do have to point out, when you're dealing with this kind of money, regardless if it's a lease back or you're borrowing money long-term to construct something, whatever the case may be, I want to ensure check and balance in government. And be it this governor or any governor, I want to ensure there's a check and balance. That's why we're here. That's why we're also elected officials, to ensure that public money is being properly spent and properly executed. So when we remove the legislature, and granted, trust me, when I wasn't here, I didn't like the legislature very much, least of all to appear before them, because, you know, senators have a tendency to want to think they know everything. So now that I'm on this side of the table, I guess I must know everything again. So I appreciate that. But I also think there's a need to ensure that check and balance. I don't necessarily know that I want to abdicate our responsibility with regards to public financing to the governor of Guam, because I don't know what delayed issue is here at the Guam legislature to approve these issues with regards to authorizing these agreements to be entered into, or if we were to do a bond. Is there anyone on the panel that can answer that question?
Senator Brown, I'm also of the opinion, like Mr. Fernandez, well, if that was the inference that you got, then, you know, we
So with the language
apologize.
in this bill, if I'm looking at Bill 310, that's what it's telling me.
We're just asking for legislative authorization to be able to, as Mr. Fernandez stated, to be able to have the authority granted by the legislature to proceed. Nobody's ever made any statement that the legislature was an impediment.
It removes the legislature. The terms and conditions of bond shall be determined by the governor.
Yes.
And it also removes the legislature also from here.
The primary terms and conditions are laid out in the bill. If, as you recall, during your time at the port, did you want to have a look at the indenture? If that's what you're asking for, you can include that.
Well, unless I'm reading the English wrong, it removes the legislature from the process here.
Once you grant the financing, then you're making it incumbent as when you were at the port for the port to pursue.
No, I understand, but if I'm reading the language as the way this bill is drafted, it's existing language that exists that's being removed.
Yes, because the TFF is what it is that we're removing simply because it is insufficient in its funding, and we change that to lawfully available funds because we need to work with you guys.
What can I ask you, what is the definition of that, lawfully available funds? Lawfully available monies are available. What does that mean?
It could mean we could use property taxes. It means we could use BPT, but we would have to ensure that revenue collections are not adversely impaired. As Mr. Burns said, the lease for Pt.1 is $10.3 million due January 1st. So we have COLA, we have a number of different obligations that are payable at the first quarter of the fiscal year, and it's very difficult to be able to make all those obligations and still squirrel away $10 million.
But why would it be difficult to come back as we deal with regular funding with the government in your budget, or any excess funding that would be appropriated by the legislature versus the administration simply determining what pot you want to take it out of?
No, ma'am, we're not doing that unilaterally. I'm stating that we're at a process here where we are going to be working with you to identify on an annual basis from any lawfully available funds, because we will have a interest and principal payment and a maintenance and insurance payment that has to be approved by the legislature annually so that this thing doesn't go against our debt ceiling. So every year, we're going to be back before you to get authorization for the payment of the obligation for the construction, insurance, and maintenance.
Can you cite me, Mr. Carlson, in the bill where it says that?
So on page 2,
it just tells me it's lawfully, that it's lawfully available monies are available.
it's on page 2, where section 2, number 2, where it says rental payments under the lease shall be payable from any lawfully available funds, monies of the government of Guam. the leaseback may be structured as an annually renewable lease with provision for automatic renewals to the extent that these monies are still available. And then number 3, the leaseback shall not be construed as a debt. So the only way that we can avoid that debt is if we come before you every year and get the necessary funding from you every year to make the payments.
Well, then maybe we would amend the bill to clarify that, because the language, again, doesn't tell me that. Probably, or anyone else that's not familiar, it doesn't say that at all. So maybe we need to amend it to clarify that.
Okay.
Okay, I appreciate it. Thank you, Madam Chair. I don't have any further
Senator, I
questions.
also believe Section 5 does expand on what Director Carlson was saying as well about rental payments made under leaseback reserves.
You're talking about Section 5?
Page 5.
Oh, page 5, okay.
Section 58D109. It does expound somewhat on that section.
Yeah, it says lawfully available monies of the government of Guam. It doesn't tell me that we're involved in that process. How do you determine what, that's why I'm saying, how do we define lawfully available monies? Especially, let's look at the existing budget where we're very specific that any additional funds that we had not appropriated were to be appropriated for other specific purposes, including tax refunds. So that's how I'm looking at it. I don't see it and interpret it that way.
When I look at line 17, where it says section shall be subject to an annual appropriation for the purpose of funding the activity set forth, I believe the referenced appropriation is the appropriation of the legislature and subsequent pledge to pay the debt service.
I think probably something would give me more comfort levels. We amend the language to make that clear. Thank you. I appreciate your input. Thank you.
Thank you, Senator Brown. Senator Taitague.
Thank you, Madam Chair. Good afternoon. Sorry it took so long to get you in here, but a very important bill was before you, but this is just as important. It's been a long time waiting for this to happen, and I was just wondering, it was first in the hands of DOE, Mr. Superintendent, and then now it's going to GITA to handle this. Is that the gist of this?
The procurement remains with DOE. What this clarifies is GITA's role in assisting with the financing part of it. So
Securing the bond.
Yeah, I think the original language is that GITA would play a role as a partner, but this is a little bit more specific with regard to the method of financing. But the legislation that's in the current law already envisions the assistance of DPW, GITA, and land management in helping with the procurement. So this kind of specifies exactly where GITA's role will be on the financing side.
I see. Okay, and then you talked about it's about $136 million. Is this figure amount?
Yeah, let me clarify a couple things. So number one was when I mentioned it in my testimony, I was beginning with an estimated cost. I mean, if it were $70 million in 2014, that would translate into a anticipated cost of $136.7 million based on the inflationary factors. That doesn't mean that's the final cost of our project. What we're trying to do here is a couple of things. One is we know that the 2014 amount is insufficient to fund the school at this point. Now we're trying to clarify what funding will be available that we can dedicate to the project, so that when we finalize the design and the structure of the bids, it'll take into account that final authorized amount. So what that means is we are still in the process of trying to ensure that the project is cost effective. And then the second piece is that we are looking at structuring it as a base bid plus additive bids, meaning the base bid would cover the essential needs of the school, and you would only be able to do some of the additive components in the, if resources are available within that authorized amount. So those are the two things that the legislature will help us with. If you can give us an updated, cap or amount that we can use to finalize the design, we will work with TRMA as they move to 100% of the design to do further value engineering as well as structure the bid so that it comes in within the authorized amount, and we can ensure that resources are available.
I see. And according to the legislation, it authorizes GITA to seek $146 million, which, you know, I looked at 136, there's a $10 million difference between what was requested and what you put down. So I can only assume that some of these costs have to deal with either the, what is it, the cost from GITA that you provide, or, you know, is that including the insurance and maintenance, or is that GITA's fee for, well, what's funny about that, Mel? You guys do receive a fee, right, whenever you go after bond, is that correct, Mel?
It doesn't generally raise the price tag by $10 million, Senator.
No, I was asking you, but do you do a fee? My question was, do you charge a fee?
GITA puts in work, Senator, so normally when people
So you do charge a fee, right?
People work, there are people, I suppose, who work for free, but
okay, so my
we don't work
question
for
is,
free, we get paid.
So I'll assume that's yes. You do charge a fee every
That's
time
correct.
you go after, okay.
It's
And of the
statutorily
146 that you-
required. I don't just charge a fee based on how I'm feeling.
It's based on what the job that you're supposed to be doing for GITA. Exactly.
Just like how your salary is based on the job you're supposed to be doing.
Right, exactly what I'm doing right now. And for the people of Guam to hear what you're supposed to do is important too, just as much, and what the job responsibilities you have. It's a requirement. You're paid with taxpayers' money too. So the question is, of the 146 that you're attempting to go after, how much of that do you feel is going to yield a yearly annual cost for 146?
Yes.
$1 million.
So the annual debt service for a $146 million transaction, is that the question that you're asking, Senator?
Yes, yearly.
Is estimated to be 12.7 million, based on an interest rate of 7.5%.
And this is for how many years?
30 years.
30 years, 0.7 million. And this will go strictly to the construction, or how much of this goes to the maintenance, insurance, and how much of this will does GITA pay for a fee, their fee tagged onto this? Is it a one-time fee that GITA charges, or is it something you receive annually for the next 30 years to oversee this?
GITA has a charge for the issuance of any of our bonds, and that's standard. And then the annual debt service payment is the annual debt service payment. And then, Lester, did you want to?
Yes. Senator Taitague, on page 3, starting on line 7, the $146 million, we mentioned earlier that we had $120 million, was the information that we had when the fiscal note was drafted and GITA's testimony.
I'm sorry, Lester, to cut you off, but what page did you say? Page what?
Page 3,
okay, page
starting
3,
on line 7.
Line 7, okay, please proceed,
Yeah.
thank you.
So the amount that we were working with was $120 million for the construction. It was only today when we found out it's 136, even though Mr. Fernandez says he's going to work it. And then the second, you see number 1 says financing the design, renovation, or construction, maintenance of the facility. Number 1 is really the $120 million, just for the construction, not there's no maintenance there. And then number 2 is financing any capitalized interest. That's what I made reference to earlier. During the time when the school was built, we're going to have to pay interest on the monies that's borrowed, not principal and interest, just interest. And that's calculated at $26 million. So that's how we got 146. What I mentioned when I started my testimony was that we're probably going to have to bump this up by about $18 million and get back to you on a revised annual amount, simply because Mr. Fernandez's estimate is $16 million over what our working number is, and we're probably going to have to bump up the capitalized interest amount. Now, the insurance and maintenance is not reflected here. I mentioned that I believe that would be in excess of $2 million. So if all things being equal, we were at $12,700,000 based upon the information in the testimony from Gita and the fiscal note. More than likely, that number is going to be closer to $15 million.
15 annually, yeah, for 30 years with the...
Yes, ma'am.
And once again, the amount taken off for the fee for Gita is how much? What is the percentage? Is it a percentage amount of the amount that's borrowed on? Borrowed on, or is it calculated some other way?
Sorry, my name is Tina Garcia, Public Finance Manager at GITA. The GITA fee, which has been in place since we started issuing bonds, is roughly less than 0.2% of the bond amount. And it's a one-time fee that we get to monitor the bond for the 30 years.
Appreciate, Lester, for you explaining the difference, because that's what my concern based on his testimony, that's all going to change. But if it looks like it may go up, did you say again that from 146, you're looking at 160 something million?
I think just to be, as Director Mendiola, CEO President Mendiola mentioned earlier, because of the uncertainty with worldwide oil, Ukraine, all this stuff, we're erring on the side of caution, and we'll probably rerun these numbers at about $164 million, not 146, and we will give you a best guess estimate of what insurance and maintenance may cost, and we'll probably just use the data from Tizen, Okadu, and JFK as examples, because we pay for insurance and maintenance on those 3 high schools. So it would probably be based upon what those numbers are panning out, so that we have some point of reference.
Okay, with regards to the financing of 2. Tina, will permitting financing of up to 146 is what we technically have in front of us impact Guam's Standard & Poor's or Moody's bond rating at all?
All bonds, I'm sorry, all bonds are individually graded like separate subjects based on their overall financials, and so the Guam these will be rated as well.
What will the funding sources be source needed to be pledged for good faith repayment?
Yeah, I think Mr. Byrne and I are still seeing eye to eye that we'd probably like to work with you guys to not have it be property taxes and probably be almost entirely BPT, just because of the steady cash flow and the ability to continue to make long-standing commitments to the people of Guam, particularly retirees, so that the cash flow is not adversely impacted because of the volatility in TEFF. TEFF alone could probably shoulder the burden, but as you mentioned, Senator Taitague, I think a rating agency would like to see, something that's robust, and I think we get $27 million a year from property taxes. If we're going to pledge half of that, it's kind of like maybe you should come up with something a little bit better. It might reflect better in the bond rating, and also to investors.
And to to confirm that, for instance...
Just come a little bit closer. It's really hard. It's
if
my hearing, not yours.
If I come any
Just
closer, I will be in my
you'll
in my
be
mouth.
eating the mic. That's okay. You can
Yeah.
eat the mic if you'd like.
Just
You're
to
hungry.
confirm that, for instance, when we make the Teton payment, like we were speaking earlier, which is due at the beginning of January, because it is deemed to come out of the TEFF payment, we have to wait until the TEFF revenue comes in on February the 20th before we can reimburse the general fund for the money that's been dispersed. And we want to try and avoid that kind of anomaly.
Yeah, I see that in the budget bill. And then my last question, Madam Chair, is I guess, Mr. Byrne, maybe you can answer this. What is the amount that we pay on all the leaseback schools that are under you right now? I think there's how many schools currently right now in the leaseback? 6? Is that 6?
I didn't bring my FY22 budget, ma'am, but the numbers are right up in the front. You know, right after the provision for income tax refunds and our bonds. So you'll see the GEFF, the Guam Educational Financing, which is the 4 schools. That's primarily paid with compact impact funds, but in a couple years, the last 3 years are not covered by compact impact. So we're going to have to absorb that cost. But the leased schools right now are just JFK that you see on the front part of the budget. Because the Teton lease in the construction of the budget, I think it's a miscellaneous appropriation. It's not up in the front. So we have to take that into consideration when you look at the budget.
Okay, so there's 4, is that what you said? There are 4 leaseback schools right now? 4? And I'm sorry, what was the amount? Mr. Byrne, do you have that? I know you're looking through your paper. Did you find it?
It's roughly, it's roughly 30 million.
I'm sorry?
Roughly 30 million.
So currently right now, for 4 schools, we're paying 30 million annually. Okay.
Actually, Senator, it's what we're paying for right now is just JFK and Teton, because the Okadu High School is part of the compact impact funding. So that doesn't affect our revenues yet. It will, because the compact is going to run out before the bonds are paid.
Yeah, and how much is that after compact is, completed? How much are we going to pay then?
That's $6 million a year.
I'm sorry?
6.
6 million. And when does it run out, sir?
I think the compact is over in 2024.
2024?
And the bonds run to 2026.
So, okay.
So there's like a 2-year overlap.
So that
unless
means
it's extended and,
If it's extended?
Yeah.
Yeah, okay. Well, so that means we're looking more like 36 million or we're looking more...
Potentially, yes.
How much annually we
Yes.
currently pay? Okay. And then if plus the 50, well, yeah.
Yes.
Yeah. Okay. Thank you. Thank you, Madam Chair.
Thank you, Senator Taitague. Speaker Terlahi.
Thank you, Madam Chair. All right. So, Ms. Gutierrez, I think we're all on the same page. We all support Simon Sanchez and the schools as much as, that's what we're here to do, just as much as you are there to do that. So, and I want the principal and the vice principals to know, I think we've always been, as long as I've been here, we've done everything we can to support this Simon Sanchez to go forward. In fact, back in 2018, we changed the entire procurement process for this school, thinking that that was going to be the faster and more cost-effective way to do that. We're here today because the bill and the cost have doubled, really, since what they were back then. And if you recall, there was actually a bid, and it was, only because of protests that had not been resolved yet when we passed another bill back in 2018 to change the entire process. On, what was, for the first time, it was, we were going to try to do it, we thought, cheaper, because we would be able to contract directly for, the design, contract directly for the manager, the construction manager, or the, upfront and different things. And then I see we paid for a surveying, but all of those took much longer than I think we had anticipated. And I know, Superintendent, that you've pointed out the issues that you had to deal with along the way. So unfortunately, yeah, we're all anxious for this to be done since 2018. And the estimate at that time was never that it would take this long. And so I think, we just all have to be very patient with each other because, even me, I'm it's pretty heartbreaking that it takes this long. But, and that the costs have actually doubled from what was set aside even prior to me becoming a senator, which was 2018. Even prior to that, that money had been set aside for Simon Sanchez. The money had been designated, the authorization had already been approved. I think that was Speaker Judy Wampat who did that. And anyway, so what I want to know is, at the time, the legislation mirrored how we had financed JFK. So I wanted to know from Gita if they could tell us, this now is a departure from the way we financed JFK. And if you could tell us what is the difference. I'm calculating from the numbers that Lester has said that we're looking at over 30 years, $15 million every year to pay for the school will be $450 million. That's just a very basic calculation, but what do you estimate that it will be at the end of 30 years, and what did you estimate the total cost of JFK to be?
I'm sorry, Madam Speaker, to just address your questions one by one. One of your questions was, this looks different from JFK. How is it different?
The financing, well, it is different, right?
Mm-hmm.
Yes.
Yes, different school, different amount, of course.
No, no, it's a different financing authorization. That's why this bill is here. Because if it was the same, you wouldn't have to come in with this amendment, right? So, yeah, what was the total amount for the JFK?
I'm sorry.
The total
this
amount.
Is the total amount. Sure.
Yeah, we estimate for the JFK over the period of the lease back.
JFK is, the issue amount was 65.4 million.
That was for finance, design, build, lease back. So the design portion has already been done. So in many ways, these are very similar. It's just that the legislature gave the resources to DOE to get the A&E work done, and it wasn't done all at the same time.
But that's the financing amount. But is that the total? I mean, after the 30, is it 30 years for JFK?
Well, the total amount is the annual lease, the annual debt service times 30.
Right. What is that for
the
JFK?
cumulative amount? If you just give me a moment, ma'am.
Tina should have it. It should be the end, the amortization.
135,131,334.
133 million?
135,131,334.
135 million. Yeah, this, compared to this, 450 million, right? So it's significant. It's huge, really, in my mind. And I know you have all kinds of reasons, but it's really, really, really significantly larger. And as the superintendent said earlier, almost double the amount from the 70 million that was anticipated back then in 2018. Yes, Superintendent?
Yes, if I could. I just want to clarify and then address that question, at least as far as I understand it. when this procurement was first set up, it was basically an all-in type of situation where one contractor would do all the work, the survey work, the design work, the financing, the construction, all in one. And what we did in 2018 or in 2019, when the protest that had stalled the procurement was resolved, we had approached it in increments so that we could get to this point, which is basically the completion of 2 phases of
Right.
the.
But I believe
so,
that
so I want to
wasn't-
make sure that it's not.
Yes.
That I don't consider it a delay. I consider it, basically.
Well, that was anticipated, but it
Right.
did take several years to get the surveying and the design done.
Well,
So
and
that was
yeah.
2019, it's 2022. I think in January of this year, you had reported that the design work was 90% complete. So,
Right,
yeah,
so-
we're still at 90% complete. And
So I'd like to, if I could clarify, again, at the end of 2019, we proceeded with the survey work pretty quickly and completed it over the summer. Then, as I mentioned, in 2019 and 2020, we were here before the legislature to address the gap in funding to be able to get us to the design phase, because we needed that to happen. And once we resolved that gap in funding, we entered into the procurement for the process for the design work. Now, I'll admit that there was a delay due to we were impacted by the pandemic at the initiation of that process and weren't able to complete it until October. But even in the original process, it was always anticipated it would be a 12 to 18-month design process. So I just want to clarify, from October to where we are today, that is 18 months, and that's why for the design component, someone who was when I first saw this process in 2013, I said, wow, that's a long design process, but for a project this big, my understanding is that 12 to 18 month design process is standard and not out of the ordinary. So where we are today then is trying to deal with the cost. I think, as you'll note, as I mentioned, the cost estimate
Yes.
that was provided.
I don't have any.
Yeah, the issue with the costs, unfortunately, 50% of those costs are associated with what our designer is based on sort of the pandemic, labor, supply chain related issues versus what you would typically anticipate as average annual inflation and other factors. If you took out the pandemic, related types of inflationary factors, you're probably looking at half that increase, right? Which would put us in the $100 million range versus the $30 million range. So the issue for us is, what to do now, given that unfortunate set of circumstances that puts us in a situation where these costs are way out of line and not projected prior to the pandemic, because I don't think anybody anticipated this type of inflation hitting us. So I think a couple of choices are to proceed in that environment, hoping that things change, our bids come in favorably and so forth, and that we can do our part to value, be very, I don't want to say value engineer, but to be very cost effective in the final design. The other option is to wait and see if this inflationary environment eases, but that then delays the project. So I think we're with you from the standpoint that GIDA's basing their financing proposal on our cost estimates. Our cost estimates, according to TRMA, for the pandemic-related costs are coming out of a December 21 school bid, a similar school bid that they use as a basis for estimating the current situation. So we're frustrated because that's way out of what we anticipated, and we had hoped that it would come in and reasonably below 100 million, or even at 100 million would have been something we could think would make sense. It's that additional component that we have to figure out whether we're going to authorize and move forward, knowing that that's where we are today, or hope that it eases in the future. But again, we don't want to see Simon Sanchez delayed. So I just want to make I think we're on the same page. But that's what we're learning from our consultant.
Well, I did hear your testimony, and
Yeah.
I heard all the reasons of the cost increase. So I'm not criticizing that any of those are false. I'm just saying that's what we're dealing with, and
Yeah.
I wanted to know the total. So
If I could follow up, if I could
Pardon?
follow up, if I could follow up, the issue with there is,
No,
once you
I have-
authorize, the only issue for us is that we're still not at the final cost for the project. So again, we're going to do our best to make sure that we consider the finances that are available and obviously the financial pressures that the government faces, and look at what the school needs. So based on our current cost estimates, I know that Lester came in and said it's 136 million because we are presenting that number, but we are looking at scenarios where we could do a base bid closer to 120 million and then additive components above that based on resources being available. So again, it'll take some trade-offs and sacrifices if needed,
Right.
but that's how we're looking at constructing it based on the final number
Yes,
that's
so I
available.
heard that too, and I support that, the base bid and then your additives. But what are you saying based on resources that are available? What resources will become available besides appropriations annually?
So, well, first of all, the appropriations piece is a critical because this is a lease back.
Yes, so which others?
Yeah, and technically under the lease back, if the government fails to appropriate the lease payment, both parties can walk away from the deal, and that's why it's not considered a debt to the government. So it is critical that every year we
Right, I
ensure-
understand that. So I'm
Now,
saying in
with
addition
regard-
to the
Yeah, with reg-
annual, if we could just, everybody just keep their answers to the questions just as directly as possible. So, yeah, in addition to the annual appropriations, what funding sources might be available?
It really determined, it really, I think for us, is based on, first of all, what the vendor bids and how low we can get the cost and whether it's be able to be covered by, I guess working with Gita, looking at the various options for financing. So we've talked about whether it comes from, a variety of sources. We're leaving it and we're working with Gita to determine what the best source of funds would be.
Okay, so maybe
We are looking at, again, because I know this comes up, is there any other source of funding outside of that? And we are looking at covering some of the costs that would normally be covered elsewhere with some of our federal funds. So this doesn't include our the FF&E costs, which are really the equipment and furnishings and so forth. We're looking at funding that, if possible, out of our federal funds. And there may be additional funds available, but the challenge is how do we move this process forward so we can get to a point where we understand the time frame for construction and completion because these federal funds expire.
All right.
So
and
if
I
we
do
can
want
get
to
to
move
the
this
point,
process forward, so that's why I'm asking
Yeah.
the questions. Yeah, the answers can just be direct to the questions. So does Gita have any additional funding sources?
No.
All right. And so that was my next question, was going to ask you, are there any federal monies that you have received or are going to receive that are going to be dedicated to this? I was going to ask you particularly, are the ARP or infrastructure funds, are you going to be receiving any? And since you talk about pandemic increasing the costs, can any of those be dedicated to this as well?
so I guess at this point, I would say yes. Yes, there may be funds available subject to the timing of the project, right? Because our funds expire in 2024, and right now, even on an ambitious schedule, we're kind of running up against that time frame. And then everything that pushes off will mean that those funds won't be available. So we are looking at whether there may be a need for any gap funding, but it really depends on if a vendor coming in saying, this is what we're going to do, this is our construction schedule, and then Gita working with us to determine, what the best way to finance this is. And if we can contribute and it makes sense and we have the funds available, we're just worried about it expiring because we, go past a certain date.
So, but as of today, you have no amounts or no particular sources that you can cite?
No, what I'm saying is that we do have funds that we have set aside for facility improvements. They are really meant for broad improvements across the school system. But in the event that we come to a point where we're looking at, an actual bid and we're looking at an actual financing package and believe that would be a good use of funds to make sure we can move this project quickly, we can, we would look at doing so. I think the only challenge is the schedule, our estimated schedule for construction and completion is, I believe, like a 24-month, for the full school to be done, phase 1 and phase 2. And again, that pushes us up against 2024 and then possibly 2025. So there is a point in time where those funds won't be available, and we would need to line all of that up to make sense of, to put the best package together.
So your, the bid or the specs that you're working on right now do not include the furnishing?
We're looking at using the ARP for that part so that it doesn't have to be included, so that we don't use lease financing for purchasing something that's going to expire in terms of its life cycle.
That's a good idea. I support that.
So.
All right, then this $15 million annual payments, Mr. Byrne or Mr. Carlson, can you just confirm, was that included in the 2023 budget? No, right? So we would have to account for $15 million in 2023, or not until the construction is done? Is that 2 years from now?
No, we wouldn't have to pay anything because we would essentially be borrowing the interest cost. That's the $26 million that I mentioned. So we won't be on the hook for the whole enchilada until 2 years down the road.
2 years from today, 15 million annually. Yeah, so I'm a little concerned about that. To just come up with 15 million on top of what we're currently paying. Do we expect any debt service to be reduced by then?
Tina and I will take a look real quick. We have a 2012 BPT that will be finished in fiscal 26. That's an annual debt service of approximately $3.3 million. We also have a 2021 BPT, and that is going to finish up in 2025 at $5 million. So there will be approximately 8.4 million or so between 2026 and fiscal 2027 that will be freed up.
All right.
Soon thereafter, the 2019 GOs, that will be fiscal 31, almost 3 million. That was for GSW, I believe that was for GSWA for the Luzon cell.
In 2031, you're saying?
Yes,
Okay.
yes, ma'am.
All right, yeah. All right. So then, could you clarify when this bill will authorize a pledge of what now looks like possibly general funds as opposed to the TEFF? So this pledge of general funds, and yet there's another provision that says the bonds will not be public indebtedness, as that term is defined by the Organic Act. It says that in two places, the leaseback shall not be construed as a debt under any applicable debt limitation under the Guam Organic Act or Guam law.
You're correct. It's written so that it doesn't impact our debt ceiling, and it's the appropriation has to be made just like JFK every year by the legislature, so that this doesn't count against our debt ceiling. You're correct.
This section 58D108, the changes to the financing. well, it gives an amount, and I know that's what the superintendent wants is an amount so they can go forward. Is there any, well, and you do have options on the design for lower amounts, like a base bid, like you said, so that's good. But this is an amount, and it says here, for the financing, the design, renovation, or construction and maintenance. We don't need the design anymore, right? We won't need that, or renovation. We would need the construction. It's strictly for construction. That's your understanding? Okay. And
the capitalized interest.
okay, and can you explain, Mr. Carlson, that's why you think this bill has to be amended and increased by 18 million?
Because what the testimony and the numbers that we got from Gita was the construction cost was 120. Today, Mr. Fernandez is saying it's 136. And so, and there is no accounting for the annual insurance and maintenance. So I will bet you the $5 bill that I have in my pocket that it'll be over 2 million. So there's where I got the 18 million.
Is the maintenance going to be a separate, or is that going to be part of the specs for the construction?
Right. So we anticipate getting that information from the bidders regarding their estimate of maintenance costs as part of the their bids. And again, regarding the 136 million that I know Lester is quoting, again that does refer to the to everything. That's the full the full package. And again, if again that means all the base and additive components would be funded. So that would be the amount to fund everything that is being designed. And so again, based on the availability of funds, we could work to address that by doing base and additives and seeing if the resources that are available at the time of the bids being submitted.
The rental payments, it says, it's rental payments shall be reserved and payable from any lawful available monies. Reserved meaning what?
So when we're doing the budget, we have reservations in August or September, but we don't actually, the appropriations don't take place until October 1st. So during the budget discussions, we will identify and reserve those amounts and make them available via appropriation effective October 1st of every fiscal year. So it basically is a fancy way of saying we're going to go through the iterations of identifying every year where we're going to pay it from, and then pay it.
But why does that have to be in law then, if it's a BBMR function to reserve? Because it's a legislative function to appropriate. So you're saying we're going to appropriate 15 million every year, plus maintenance maybe, or something. But why, the reservation part, what is that doing for the other side, I guess?
Yeah, so bondholders want to be very comfortable knowing that prior to the onset of the fiscal year, that the bond payments, which are only done annually and not for any period longer than 1 year, have been satisfied by the legislature from funds that will then be available via appropriation October 1st. So it's
okay. I guess let me just rephrase my confusion. Is this, so we had reserved prior to this bill, currently we reserve pursuant, I think this is the TEFF, right? There's a reservation of money and the authorization that could be pledged because we had reserved it. But this bill's now saying we're going to appropriate every year. This pledge Yeah, but I guess I'm
Yeah,
trying,
Madam
who's going
Speaker-
to decide where it gets reserved from? If it's not the legislature anymore.
It is the
yeah.
legislature. It is the legislature. And to answer your question about the prior authorization, that was based on the ability to have a lease in place. We never had a lease in place. So therefore, the $5 million reservation was never necessary because we never got a school built and a lease in place.
Right, but we had that dedicated,
Yes.
and so that should have set the budget, right, for, what kind of lease we were going to put in place back then. That's
Back
why
then,
that was
exactly.
passed.
Yes.
Right, and this one, it just concerns me. I will continue to look at it, but, so, do you think this bill provides a cap on the pledge that can be made without any further legislative approval, or does it pretty much say on section 4 of the bill, page 5, that any amounts can be reserved and pledged?
We're going to have to refine with you what it is we're pledging. So this is the public hearing on the bill. We're going to have to get consensus, and Mr. Byrne and I have already gave you our input as to where we think the pledge should come from. We're going to need legislative authorization for that pledge, and we're going to need legislative authorization for the amount that we're going to go out and
Right.
borrow.
Okay, so I will look forward to that reiteration of this bill. Can I ask then one more question to Gita? So they had asked you earlier about fees for, bonds, and you get fees on every bonds that we go for. So are the fees a one-time fee, or are they paid, do you get fees every year for 30 years?
One-shot deal, ma'am.
One shot? Okay. Do you know the amount that it would be then if it was 146?
Yes, just give me a moment to confer with Tina.
Okay. Thank you. Thank you, Madam Chair.
Thank you very much, Madam Speaker. We're going to take a brief recess to restart our feed. We need to reset it. Thank you.
It's approximately 292,000, ma'am.